All right, good morning. I'd like to call the Tuesday, August the 29th, 2023 Board of Funeral Directors and Embalmers meeting to order. And if you've noticed on the way in, there is a public comments form if you'd like to sign in to do so. And Ms. Bohannon, if you would please call the roll.
Fred Berry.
Present.
Anthony Harris.
Present.
Tanya Skell-Haynes.
Present.
Chris Lee.
Here.
Wendell Naylor. Scotty Porsche.
Here.
Pam Stevens.
Here.
Mr. President, we have a full quorum.
Thank you, Ms. Bohannon. And this morning it is a pleasure to welcome our new board member, Mr. Wendell Naylor, who was appointed to represent our Western Grand Division. So we'd like to say welcome to you and give you just a few moments to address the board and tell us a little bit about yourself.
Glad to be here. For the last 30 years. That's been an honor in itself. Third generation funeral director. My grandfather owned funeral homes down in the lower part of Mississippi. My mom was a funeral director embalmer, and so I'm a funeral director embalmer. That's about all I can say. Just happy to be here.
Welcome.
Welcome, absolutely. We're honored that you're here. We invite you to get involved, ask questions, and it's an honor to have you join us. This morning you do have the agenda before you. We'll take a moment to review that and then take a second to approve.
Approve. Second.
All right, I have a motion by Mr. Berry, a second by Mr. Lee to approve the agenda as presented. All in favor?
Aye.
Any opposed? All right. We also have before us the June 13, 2023 minutes. If you'll take a moment to review those, if there's any corrections or additions that need to be made, we'll talk through those.
Move for approval.
Second.
All right. We have a motion by Ms. Stevens, a second by Mr. Berry to approve the June 13 minutes. Any other discussion? Not all in favor, say aye.
Aye.
Any opposed? All right. We're going to turn to Mr. Bryant for our legal report. Good morning, sir.
Good morning, board members. The first complaint we have is complaint number 2023-011631. Complainant, a competitor funeral establishment, stated that on February 13th, 2023, they received a call from an employee of respondent establishment stating that they had received a decedent that should have been brought to complainant. Respondent provided complainant the contact information of the next of kin. Complainant alleged that when speaking to the next of kin, they said the paperwork was confusing because they were under the impression they were using complainant service. The paperwork said it belonged to respondent establishment. Complainant stated they called respondent back to let them know that the decedent was, in fact, supposed to be at their location, as the next of kin was filling out their paperwork. Complainant stated that a similar occurrence happened on March 2nd, 2023, when complainant received a call inquiring about their loved one to be picked up from the medical center. After speaking with the next of kin, complainant determined that they had believed they called a 1-800 number for a very similar sounding establishment, and that they were filling out paperwork for respondent establishment. Complainant informed them that they were not associated with the respondent, and that they would need to call them directly. Respondent replied, stating that they made the initial call in February because the hospice paperwork showed complainant's address, and that they were trying to do the right thing by contacting them since their address was listed. Respondent stated once it was discovered that it was not complainant's case, they met with the family. Respondent stated that the family brought in some old, outdated paperwork from when they had worked with the similarly sounding establishment in the past. Respondent informed the family that they had changed their paperwork and that ultimately they did not feel comfortable performing the cremation and declined the case. Respondent referred the family to another funeral establishment. Respondent admits that the situation is confusing in their area because the establishment they had previously performed cremations for and the complainant are very similarly named establishments. Note for added context, although neither complainant or respondent articulated it in their complaint or reply, It appears that respondent would perform cremations for an establishment with a similar name to complainant's establishment name. Due to circumstances, respondent has severed the working relationship with the similarly named establishment. Out of utmost caution, legal sent this case for investigation. First, the investigator spoke to 2 members of complainant establishment who largely reiterated what had been in their complaint. One employee stated that over the years, several families and even hospitals had called them intending to speak with the similarly named establishment. The investigator spoke next to respondent, who stated that in the past they had performed cremations for the similarly named establishment, but they were no longer doing so. Respondent stated that while working with the family, respondent became increasingly uncomfortable with the circumstances and ultimately referred the family to a different funeral establishment. Respondent stated that he did his best to handle the situation in as professional a manner as possible, including making the removal, contacting a competitor, meeting with the family, storing the body in a refrigeration unit, honoring the request to release the body to another establishment when the family had procured a new one, and did not charge the family for any of these services. Finally, the investigator followed up with the new establishment respondent had released to on behalf of that family. The investigator confirmed that respondent had released the decedent as he had claimed. Based on the above, the complainant was unable to show any violation of applicable rules or statute on behalf of respondent establishment, and no violations were discovered during the process of the investigation. Therefore, we would recommend closure.
Maybe I'm confused, but there was a part in there that said that the paperwork had been changed. The respondent informed. Did the respondent change the paperwork, or did the family change some form of paperwork?
My understanding is that respondent used to have this professional relationship with another establishment, and for reasons unknown to me specifically, but they have severed that professional relationship. From my understanding is that the family had the old paperwork from when that relationship was still in place, and that the establishment had updated paperwork, and that the family just had gotten the old paperwork.
We accept council's recommendation for closure.
Second.
All right, I have a motion by Mr. Berry, a second by Mr. Lee to accept legal's recommendation of closure. Any other questions or discussion? If not, all in favor say aye.
Aye.
Any opposed? All right, number 2.
Number 2 is complaint number 2023-019061. This complaint was administratively opened following a routine inspection conducted on April 12, 2023. During the course of the inspection, the inspector determined that respondent's establishment license had expired on February 28, 2023, and was not reinstated until April 3, 2023. During the time of the invalid license, respondent establishment acted in capacity of a funeral establishment with an expired license for 18 decedents. Additionally, the inspector determined that the person who signed most of, if not all of, the permits for cremation of human remains on behalf of respondent establishment was not a Tennessee licensed funeral director, but instead only a crematory operator certificate. Finally, an employee of respondent establishment provided that the crematory retort was not operational from February 25, 2023 through March 14, 2023 due to full repairs on the retort. Respondent replied, stating that the reason the license renewal was delayed was due to the fact that respondent establishment was not linked to their core list of establishments. Respondent stated that they notified the call center, but that the call center provided conflicting information as to whether they should or should not operate during this period. Respondent stated upon resolution of the software linking issue, payment and reinstatement fines were paid immediately. Respondent further confirmed that the retort was shut down for a significant period of their unlicensed period. Note, the board office communicated with the establishment manager on March 3rd, 2023, March 16th, 2023, and March 29th, 2023 regarding the expired status of the establishment, and according to Tennessee Code annotated section 62-5-316, this license was invalid and the establishment shall not be operated until such time as the license has been renewed or reinstated or a new license has been issued. So based on the above, we would recommend a $500 civil penalty to authorize via consent order and a formal hearing if necessary.
The board office contacted them 3 times concerning the expired license.
Correct.
Correct.
And 18 decedents were cremated during that time period. Even though they were closed, there were still 18.
Is it 3 months of not being licensed? Or
It's just a little over 1 from February 28th, so right at the end of February, and then we're reinstated on April 3rd. So I guess about 5 weeks or so.
The fact that the permits were signed by a non-licensed individual seems pretty serious to me.
Feel the fine that you're recommending is more lower or in line with what we've done in the past?
I think generally it's in line. Primarily, this establishment doesn't have any disciplinary history. This does seem like, from at least my knowledge, that this is the first time they've had a situation like this. 500, I think, usually when we do what we've done historically is when it's been a short period of time and it's their first offense, we usually assess at 250, unless during that short period of time there was a large service of decedents or consumers while unlicensed, or if there are other kind of outstanding issues, which I would say the crematory operator certificate being the one to sign that rather than a licensed individual would qualify.
Is there an explanation by the provider as to why they didn't have a licensed director?
To my recollection, and I can double check this, I don't believe in their response they addressed that. I think they primarily addressed just their issues of updating that expired license. I guess my understanding and is that it's not that they didn't have anyone there licensed. It's just that when they were signing that, they just let the wrong person sign it. That's my understanding of the situation, at least, because there was no finding in the inspection report that there was no licensed individual at the establishment. They just let the wrong person sign that document.
We run into the issues with licensing expired quite frequently, but this is a little different with the non-licensed person signing. So I think 500 is typically kind of what would be the fine for the licensing issue. So I'm just not sure about the $500 civil penalty, if that's.
You remember if they gave a reason as to why a licensed funeral director didn't sign? Was it ignorance? And, ignorance is not a bad term. It's that, that they didn't know or thought that just a certified crematory operator could sign.
To my knowledge, they didn't provide any information on that, but let me double check. It won't take but a second to pull that up.
Typically, in a situation like this, routine inspection, did they just look at the inspection period that the license was out of date to see if proper paperwork was being signed? And do you know?
Check and see. I think on this one they did a complete inspection. We can check and see. Typically, if it's a funeral director and they've done a recent inspection, if it's a funeral director and embalmer's license is expired and they've done a recent inspection of the establishment, they just go back and check the paperwork for the expired funeral director and embalmer's license. But when it's an establishment that's expired and when they've been notified this many times, I think they would have done a complete
inspection.
With them out the license.
So, Mr. Lee, to answer your question, their response is essentially entirely about the expired license. They don't reference this individual at all in their response.
Thank you.
And from looking at the inspection report, I'm under the impression it is a full inspection.
Hello?
Roger Bates
Oop, who's that?
is now joining.
Oh. Hey. Have something more. I'm going to make a motion just due to just not the licensing issue, but the issue with the crematory operator, or the permits not being signed by the licensed funeral director. I'm going to make a motion to up that to $750 civil penalty.
Okay, we have a motion by Mr. Berry to up the civil penalty to $750, authorizing via consent order and formal hearing if necessary. Any further questions or a second to the motion?
A second.
All right, I have a second by Ms. Haynes. I've got a quick question here. Would it be wise to send a letter of instruction along with this or not?
I don't think there's any reason not to. There's certainly no harm in doing so. If I guess specifically, I can assume what I think the letter of instruction would be, but just if the board wanted it to pertain to something specific, then just let me know, and I'm happy to include that. And also, just for transparency, it was not a full inspection.
Which means it was recently inspected, and the inspector went back to look at this specific issue. If it had not been recently inspected, then they would have done a complete inspection.
The inspection was on the crematory, not the funeral home.
It is a crematory. This
Okay.
license is for a crematory itself. It doesn't operate as we would call a funeral home. It's strictly for the cremation of bodies.
Okay. Further questions on this one? All right. All in favor of the $750 penalty, say aye.
Aye.
Any opposed? All right. We're moving along to number 3.
It's complaint number 2023020231. This complaint was administratively opened following multiple requests and notifications of an owed reinspection fee on behalf of respondent establishment. Specifically, the department had conducted a reinspection fee for respondent establishment on January 11th, 2023. Detailed in the invoice, respondent has 20 days from the receipt of the invoice to pay the outstanding reinspection fee. The invoice was delivered to respondent on January 13th, 2023. On March 2nd, 2023, respondent was sent a reminder regarding the reinspection fee. Respondent was again sent a reminder of the reinspection fee on April 18th, 2023. 3 days later, on April 21st, 2023, because the reinspection fee still had not been received, this complaint was administratively open. Legal contacted respondent regarding the delinquent reinspection fee, and as of June 20th, 2023, the reinspection fee has been received. However, due to that delay in paying that reinspection fee, we would recommend a $250 civil penalty, authorized via consent order, and a formal hearing if necessary.
They say why they had not submitted this.
They did not. I essentially had to, I just reached out directly since, in my experience, when it's kind of a more administrative thing, we can kind of get the issue resolved a little quicker in that case. And I just let them know that that fee was outstanding. And I think a day or two after our conversation, it had been paid. But they didn't offer any explanation while we were on the phone.
Move for approval on the $250 civil penalty.
Second.
All right, have a motion by Ms. Stevens to accept legal's recommendation, $250 civil penalty authorized via consent order and formal hearing if necessary. And then second by Mr. Berry. Any further questions or discussion? If not, all in favor say aye.
Aye.
Any opposed? All right, number 4.
Next complaint is complaint number 2023-021211. Complainant alleged that respondent had failed to reimburse remaining funds from the service. Complainant alleges that the specific point of overcharging came from an itemized charge of embalming from respondent establishment. As complainant contends, the decedent had already been embalmed at a separate establishment prior to being transferred to respondent establishment. Complainant attached a copy of a cashier's check purporting to support complainant's claims. However, the check had been made out to a cemetery, not respondent establishment. Respondent replied confirming that the contract and payment complainant referred to was an agreement made with the cemetery and was entirely separate from the establishment. Respondent agreed that the contract they had on file, that the complainant did not attach, showed a charge for embalming and transfer of remains to the funeral home, but that those were the costs that the previous establishment had charged respondent establishment for, not a double billing for the same service. In a rebuttal provided by complainant confirmed that they had originally taken the decedent to a different establishment, but later had the decedent transferred to respondent due to financial disagreements with the initial establishment. Based on the above, it appears that complainant believes that the decedent was embalmed by the initial establishment and then embalmed a second time by the respondent establishment, resulting in an additional charge. Based on the information provided and contained in the respondent's reply, the embalming charge from respondent was for the costs associated with the initial embalming, not a second embalming at respondent establishment. Further, several of complainant's additional grievances are with the cemetery, not the respondent establishment. Respondent states that they were charged by the preceding funeral home for the costs of transfer and embalming, and based on the above, we would recommend closure.
We approve council's recommendation for closure.
Second.
All right, we have a motion by Mr. Berry, a second by Mr. Lee to accept legal's recommendation of closure. Any further questions or discussion? If not, all in favor say aye.
Aye.
Any opposed? All right, moving along to number 5.
Next complaint.
Harris, I
Yes,
would
sir.
like to accuse myself
All right.
of this.
Let the records reflect that Mr. Naylor is recusing himself of number 5, and we'll just ask that you step out in the hall, and we'll get you as soon as this is over.
The next complaint is complaint number 2023-024441. Complainant alleged unprofessional conduct on behalf of respondent funeral director. Specifically, complainant alleged various workplace disputes, including respondent allegedly pouring embalming fluid into complainant's beverage, threatening complainant while she was pregnant, quote, digging into the death of one of complainant's family members, and, quote, stalking the family during the decedent's service, and that respondent had made comments about complainant, quote, being racist towards her, end quote. Complainant further alleged that respondent had misrepresented themselves as a licensed funeral director prior to taking the state board exam and had been condescending towards her in the workplace. Complainant attached several screenshots of text message conversations purporting to show the condescending nature and representation of respondent as a licensed funeral director. However, the particular post attached to complainant's complaint was a generic shared post on Facebook in which respondent did not specifically claim to be or hold themselves out as a licensed funeral director. Respondent confirmed that she and complainant had previously been employed at the same establishment from August 5th, 2022 to March 10th, 2023 as removal technicians. Respondent stated that this complaint was filed nearly 3 months after respondent had left the establishment and filed 6 months after the alleged incident date. Respondent vehemently denied the allegation, stating that she had never threatened complainant or her unborn child or stalked complainant or her family. Respondent stated that they received their funeral director's license on February 23rd, 2023 and resigned shortly thereafter to work at a different establishment. Based on the above, the overwhelming bulk of complainant's allegations and provided proof involve workplace disputes. Proof supplied by complainant regarding respondent allegedly holding themselves out to a licensed to be a licensed funeral director prior to receiving licensure did not rise to the level of violation, as the post was a generic shared post that did not directly identify, imply, or communicate respondent as a licensed director that could potentially mislead the public. Based on the above, we would recommend closure.
Move to accept recommendation of closure.
Second.
All right, we have a motion by Mr. Lee to accept legal's recommendation of closure, second by Ms. Stevens. Any further questions or discussion? All right, all in favor say aye. Aye. Any opposed? All right, we'll pause just a minute to get Mr. Naylor. All right, we're ready for number 6.
Number 6 is complaint number 2023-026451. Complainant alleged that upon the death of the decedent on June 16, 2020, complainant hired a respondent for the service. During that process, respondent asked if complainant wanted to add the engraving of decedent's death date onto the existing headstone, and complainant stated that they would. Complainant stated that they had signed a contract and had a receipt to show that it had been paid in full, but that as of now, the engraving had still not been added. Respondent replied stating that the person at the original company they used to engrave the date of death, quote, has been sick and is still currently sick, end quote. Respondent stated that as of June 7th, 2023, respondent found a different company to provide the engraving of the day of death. However, the new company uses a different font, so complainant requested to have their money refunded. Respondent stated that they promptly wrote a check out to complainant for what they had paid, and that complainant had been pleased with that resolution. Based on the above, we would recommend a letter of warning.
That's the respondent's answer, or during your investigation that the complainant is pleased with what's going on now?
That was the respondent's answer. Just to follow up and be sure, I spoke to complainant on 2 different occasions. One when the complaint first came in, kind of just as a follow-up to make sure everything was okay. And speaking with the complainant, they seemed satisfied with the resolution.
Here's a long time.
It is.
Everybody's satisfied. I'll make a motion that we do a letter of warning.
Second.
All right, I have a motion by Mr. Lee to accept legal's recommendation, letter of warning, second by Mr. Beery. Any further questions or discussion? If not, all in favor say aye.
Aye.
Any opposed? All right, moving along to number 7.
7 is complaint number 2023-026851. Complainant, wife of the deceased, alleged unprofessional conduct on behalf of respondent establishment. Specifically, complainant stated that respondent had received the decedent and his belongings under false pretenses. Complainant stated that she was informed of the decedent's death on April 26, 2023, in a different city in Tennessee. Complainant stated that they traveled to where the decedent had died and met with the mother of the decedent. Complainant provided that, quote, the decision was collectively made to contact respondent to transport my husband back home, end quote. Complainant alleges that they reached out to respondent at 9 a.m. on April 29, 2023 to receive the decedent, but that respondent did not answer. As complainant alleges, they called several times throughout the day and even drove to respondent establishment and attempted to enter, but discovered that the door was locked. Complainant said they finally received a call from the mother after 8 p.m., stating that they could meet the following morning because the decedent's body had not arrived yet. Complainant claims that the following day they met with an employee of respondent establishment who confirmed complainant that the decedent's property had been released to the mother. Complainant further claimed to have contacted the medical examiner and determined that the property had been picked up at 7:04 a.m. on April 29, 2023 by respondent establishment. Complainant contends that they were then refused entry to respondent establishment to receive the body and personal belongings, and contends that respondent misrepresented when they had received the remains and body, as complainant alleges it had been in their custody from noon of April 27, 2023. Next, complainant stated the following day they made the decision to have the decedent transferred to a different establishment, and that respondent charged for the release of the decedent. Finally, complainant alleged that despite having the deceased released, the mother of the decedent only released the decedent's clothing, but no personal property. Respondent replied, stating that on April 26, 2023, the mother of the decedent was contacted by the police department and the TBI about the unforeseen death of the decedent. The mother traveled to the city where the decedent had died and made contact with the police department and the TBI, where both agencies designated the mother as the next of kin. Respondent stated that the mother stayed overnight, and on April 27, 2023, the mother went to the medical examiner to identify the body of the decedent. At this point, the mother gave permission to perform an autopsy in response to the medical examiner's suspicion that foul play may have taken place. On April 28, 2023, after the completion of the autopsy, respondent was informed that the decedent's remains were ready to be released and that the mother had been listed as the next of kin. On April 29, 2023, respondent received the remains of the decedent at approximately 4 p.m., and that shortly after the embalming concluded, the property of the decedent was released to the mother based on the information received from the medical examiner. On April 30th, 2023, respondent was made aware of complainant, the estranged wife of the decedent. Respondent stated that at that time, complainant was extended an invitation to view the body of the decedent. However, respondent stated that complainant was, quote, erratic about the time it had taken for her to view the decedent, end quote. Respondent stated they attempted to inform complainant on the process of receiving remains and the protocol of a complete embalming following autopsy, hence the less than 24-hour turnaround from the time respondent had received the decedent's remains. Respondent stated that shortly after arriving at respondent establishment, complainant became, quote, belligerent, and that, quote, her communication was disorderly to say the least, end quote. Respondent stated that staff members, not including the mother of the decedent, met with complainant, where complainant was made aware that the decedent's property had been released to the mother based on information received from the medical examiner's office. On May 1st, 2023, respondent establishment was contacted by a different establishment requesting the remains of the decedent at the request of complainant. Respondent stated that they quoted the new establishment the fee for transport and complete embalming. However, respondent stated that they willingly took half the amount of the cost in order to, quote, wash their hands of the situation. On May 2nd, 2023, the remains were released to the new establishment at the request of complainant. Respondent stated that throughout the process, complainant's, quote, antagonistic approach was very disrespectful and threatening, end quote. Complainant provided a brief rebuttal in which she purported that she would present additional evidence to corroborate the accuracy of her version of events. However, to date, complainant has not provided any additional information. Based on the above, regarding the initial determination on next of kin, respondent relied upon the determination of the medical examiner denoting the mother as the next of kin. Upon learning of the complainant's existence on April 30th, 2023, despite what appears to be difficult, intense dealings with the complainant, respondent ultimately allowed her to make the decision regarding disposition of the body, as complainant requested transfer the following day on May 1, 2023. Regarding the property of the decedent, again, respondent released the property to the mother based on the next of kin determination that had been provided by the medical examiner. Respondent released the property to the mother on April 29th, 2023, and learned of complainant the following day. Ultimately, respondent used reliance information obtained from the medical examiner in determining next of kin, and when made aware of complainant, abided by her decision related to the disposition of remains. Based on the above, we would recommend closure.
That's a lot.
Yes.
I'll make a motion that we accept council's recommendation of closure.
Second.
All right, we have a motion by Mr. Berry, second by Mr. Lee to accept legal's recommendation of closure. Any further questions or discussion? Not all in favor say aye. Aye. Any opposed? All right, number 8.
Number 8 is complaint number 2023-024461. This complaint was administratively opened on May 22nd, 2023, following a routine inspection conducted by the department on May 10th, 2023. During the inspection, the inspector determined that the manager and only full-time employee of this establishment was also employed at a separate funeral home to provide embalming services, according to a conversation the inspector had with the owner. The inspector stated that the manager had not been present at any inspections and that the owner, who is not a licensed funeral director, is the only one there. Further, in June of 2020, a check in the amount of $575 was submitted for the renewal of the establishment license expiring June 30th, 2020. The check was later returned by the bank for insufficient funds. At the time of the inspection, the funds for the returned check still had not been paid. Next, the inspector determined that prices on the CPL did not match the prices on the GPL. Finally, respondent's website advertises that they offer pre-need sales and pre-arrangement counseling. Respondent establishment does not have a pre-need seller registration. Respondent replied first, stating that they denied being employed at a separate funeral establishment. Respondent attached a statement from the owner clarifying what they had communicated to the inspector, that the manager may be performing embalming for another establishment on their off hours. Specifically, respondent stated that they had not worked for the other funeral establishment since May of 2020. Respondent also stated that they were present for an inspection of this establishment back in 2020. Respondent further stated that as of May 8th, 2023, the dishonor check had been paid in full. Next, respondent stated that the inconsistencies between the CPL and GPL were typographical errors that had now been corrected. Respondent attached a copy of the updated GPL to show it had been amended. Finally, respondent stated that the website only provides a complementary pre-arrangement form and tool to be utilized by the consumers in order for them to organize the information that would be needed at the time of death. Respondent provided that this establishment has never engaged in a contract for pre-arrangement, and to avoid any misrepresentation, the page has been removed from the website. Based on the above, we would recommend a $250 civil penalty to authorize via consent order and a formal hearing if necessary.
The check that was returned in 2020 was just finally paid May 8th of 2023.
Correct. This is obviously when that original check came in was before my time here, but I guess just speculating, and it may not even be fair for me to do so, but I did not get the impression that it was an intentional attempt to defraud or misrepresent or anything like that. I think it's something they sent the check in, didn't realize that it bounced back or came back, and then when that was made aware in this inspection, hey, by the way, you have a check from 2020 that had insufficient funds, it appears that they got on top of it. Again, there's still a concern that it was almost 3 years.
So did they have a valid license in that 3-year period?
So I would say that they were missing that payment for it. The license would still ultimately have been valid. That was a just kind of a insufficient fund mistake that had, albeit 3 years later, been corrected once that was brought to their attention.
Not only did we have that, we had a wrong GPL and
CPL didn't match the GPL,
right,
I think.
and then there was false advertisement on the website, correct?
I would say for the advertisement, what our auditors generally do, and I'm glad they do this, I would much rather they do it this way than the other way, is that if they think it's something that toes the line or maybe is close to it, they will include it so that when it gets to my desk, I can make the determination, okay, legally they're fine, or legally, yeah, that's a close call, but that's a violation. I would say without having been able to view the website as it was at that time, I don't know how close that may have been, but the fact that we've seen that more than once where they are not specifically offering, hey, come in for a pre-need, but then our auditors or inspectors tell them, hey, that's a little close, and then they take it down. So it's not great that it was maybe close, but to my mind, at least legally, they have cured that issue.
We feel comfortable pretty much in the entire investigation. The only thing we're kind of dealing with was the lapse of the license when the inspection was done.
Agreed, yes. I think that 3-year issue is the main problem of that. That should have been, I don't know what respondent knew or didn't know for these past 3 years. When it was brought up, they fixed it, which is great, but 3 years, as was said earlier by one of our board members this morning, 3 years is a long time.
For a reason why the fine is so low here?
So essentially, in going through this, the pre-need issue, again, in my mind, legally speaking, has been cured. The CPL GPL typographical error, that's certainly a problem. Again, that's something of, it appears when that was pointed out to them, they fixed it, which is great. Though I guess that's ultimately up to the board whether fixing it when it was brought to their attention is enough. So all of that in mind, stating that when they had these things pop up, they fix them. To me, legally, that's why the recommendation of 250, though I also acknowledge that, that's the problem existed in the first place. Does fixing it absolve it? And with the 250, I would say no, they're still receiving a civil penalty. But again, if the board feels that those kind of mistakes quantify a larger penalty, then that's certainly within the board's purview.
If the issue with the GPL and the caster price list was like the wrong amount for the range, or was it a specifically stated product mispriced on the GPL?
Double check on that. I know generally these all run together for me after a while, but generally speaking, what we see is that the range is off. It's just a typographical error. But let me check and make sure it wasn't.
That's what I was thinking it was, Fred, because you won't have pretty much all your caskets on the GPL. I figured it was a range. I think
it'd be more serious if it was a stated price and you were overcharging on their contract or something like that.
Yeah, it seems to primarily be the ranges. There are admittedly looking at looks like 6 inconsistencies between the CPL and the GPL, but they do all appear to be for the ranges.
So administratively, how does that work if there's insufficient funds? Then there's a letter sent out from the department on that, or?
Bohannon can answer that better than I can.
What we do is we send out a reminder letting them know that the fines are due, and we try to do that at least every 30 days until the fine is paid. That's why you'll see multiple requests for for the same item.
They get a signed receipt on that, or is that emailed? I think sometimes I get those via email too, but was it a signed receipt letter that you sent?
No, I send what I do is I send an email, and then I upload the email to their file, just letting them know, because it's not a certified letter. Only certified letters come from our legal department now.
Okay.
Does that answer your question?
Yeah, or a letter. It was just an email.
It's an email with a letter attached to it, and we keep that on file, so we'll know that we have notified them multiple times, and that way we can put that in whenever needed.
So, with there being insufficient funds, then they're not issued an updated license, right?
That's what that was my question a while ago. It sounds like the check was mailed, the license was updated, and by the time the check got to accounting or whatever and sent back, they already had an updated license, and the insufficient funds wasn't followed up on.
If they received a license with the updated, I could see where that would present some confusion. But
Ms. Bohannon, you got a response on that?
I was just going to say what Mr. Lee said is exactly right, because it takes a minute for it to go through accounting, and what accounting does is they notify us, and then we notify the establishment or the individual. So it does automatically renew it, because at the time we don't know that the funds are insufficient. So
Well, we'd like to get people for 2 reasons to pay by credit card. One is if they're paying online and using ACH, if they type a incorrect account number in, we don't know, the accounting people don't know it, so they go ahead and take it, but then that's going to cost the establishment an individual a $20 fee because they typed in their incorrect checking account number. The other thing is, if they pay with credit card, they don't have to pay any fees. No extra fees are assessed to them for using it, no processing fees. And also, if the credit card's not good, or if the number's mistyped in, they're going to know it right away. So even though they can pay by check and use ACH and do it that way, we highly encourage people to pay by credit card. It's beneficial to them. It's beneficial to us too, because you don't get the charge back on the credit cards.
So do you think the civil penalty suggested is more geared toward the issue with the insufficient funds, or more geared toward the GPL CPL problem?
Yeah, I would say for me, when putting this together, it was more geared towards the insufficient funds of, again, 3 years, long gap to not address that issue. And again, it's, I do have in our file that the inspector included a invoice for returned e-check saying that it didn't go through. That was dated August 28th, 2020. So they got at least one notice. I don't know if from, what Ms. Bohannon said, may have gotten more. It wasn't included in the inspection report, unfortunately, so I can't say that for certain. But it was the kind of my driving violation in this one when reading this and putting it together was the insufficient funds.
I almost think it needs to be raised personally, but that's my opinion.
I'll make a motion to approve council's recommendation.
Second.
All right, I have a motion by Mr. Berry to accept legal's recommendation, $250 civil penalty authorized via consent order or formal hearing if necessary. Second by Mr. Lee. Any further questions or discussion? All in favor say aye.
Aye.
Any opposed? That would be aye. All right, number 9.
Next is complaint number 2023-03151. Complainant alleged that respondent funeral director failed to file the death certificate in a timely manner. Specifically, complainant stated that the date of death for the decedent was April 25th, 2022. Complainant stated that respondent did communicate that there was a backlog, but that they went to their county's health department several times and stated that they did not have records. Complainant stated that the main purpose of the complaint was in order to receive the death certificate. Respondent replied, confirming the date of death as complainant described. Respondent explained that the hospital the decedent died at refused to sign the death certificate because they were not the primary physician for the decedent. Respondent further stated that at a separate hospital, they were told by the hospital that, quote, the floating physician wasn't signed into the system, end quote, and that no other doctor would sign off on the certificate. Finally, respondent said that because no other physician would sign the certificate, they had no choice but to send it to the medical examiner's office, that as of the day of their response, July 10, 2023, they were still waiting. So one thing I will add to this is that I did my best to track further information down. I called complainant. The number had been provided. Classic voicemail box has not been set up yet. You can't leave a message. I called respondent and left a message. Had not heard anything back. I even called the health department to see if it had gone through. And of course, our decedent had a very common name. So it was very difficult to, I guess, kind of answer that question as, okay, has it been supplied yet? Unfortunately, I do not know whether that death certificate has gone through at this point. So with that in mind, based on all of that, I would recommend a $1,000 civil penalty to be reduced to $250 if respondent supplies the death certificate to the family within 30 days of the receipt of this consent order. And included with that consent order will also be a letter of instruction that includes language as to how respondent should make continued contact with the medical examiner's office and the vital records section of the Department of Health, and that to be authorized via consent order in a formal hearing if necessary.
Real quick, do you happen to know, and I don't think I read this, between April 25th, 2022, when they finally decided to send it to the medical examiner?
So my understanding is that, and what I will say is complainant provided a very small paragraph and respondent provided an even smaller paragraph. My understanding is that it was not just July of this year that it was sent to the medical examiner's office. My impression of the information supplied is that they had sent that earlier and had kind of just said, I'm waiting on it. And I don't know if they've followed up. I don't know what additional communications or efforts they've made to try and expedite it, to move it along. maybe nothing, maybe everything, but they didn't supply that information, and that's part of why I tried to reach out to them. So, to answer your question, Mr. Lee, I believe that was sent to the medical examiner much earlier in the process, but my impression has been that they've just kind of been resigned to say it's with the medical examiner's office. I'm waiting on it.
That's too easy of an answer. I mean, it doesn't sound like they followed up at all, and we all know with family and banking and insurance and all that, they can't do a whole lot without a death certificate. I believe more effort could have been put into that. If a doctor's going to refuse to sign or didn't see that patient or whatever, it should have went to the medical examiner, and the medical examiner can determine if a doctor's responsible, or they can do a chart review and issue that death certificate. But if that family is still, they don't have it yet, as far as we know?
As far as I know, as far as whenever the complaint was filed, and I would assume if the respondent had provided it at the date of their response, they would have said so. So as far as I know, they do not have it yet.
They died in the hospital and there's not.
Yeah, if they were an inpatient, then the attending would have been responsible. I don't know if it was an ER death or what that was, but there's more avenues to resolve this, I think.
And one thing I'll just kind of say, I guess less for the board's benefit and maybe for any licensees and potential future respondents out there, is that the more information you can provide, the absolute best. Again, I have no idea. This respondent may have done all of that, and they may have followed up, and they may have been for the last, however many months slaving away to try and get this taken care of. We just don't know that because they provided a 4-sentence paragraph.
But our part of the investigation entail contacting the medical examiner to see where it is. Maybe I'm just.
I mean, it's certainly possible. It's certainly something we could do. This one was ultimately not sent for investigation just because it seemed. Usually, we do those whenever it's an issue of maybe a fact determination or something like that. In this instance, it seemed pretty clear that from the information provided, they hadn't followed up probably as well as they should have. So this one wasn't sent for investigation. Again, with kind of just the information being as straightforward in the complaint and response as, I don't have my death certificate yet. Yeah, I'm still waiting on it.
So since the respondent only sent a very little information, would it not be wise for us to do investigation here to make them prove some stuff?
We can certainly send this one for investigation. I will say, not that I am, and I'm not speaking about this one specifically, I'm just saying more in general, not that I'm reluctant to send ones for investigation. I guess it's ones that, again, when they're kind of as straightforward of a violation in my mind as I don't have my death certificate yet. Yeah, I'm still waiting. I usually hold back on those, but I agree there's definitely information to still be gathered here. So if the board feels like they need more information on this and want it sent for investigation, I'm happy to do that.
I'm going to step out and make a motion there that that's exactly what happens, and then can it be represented next month or whenever it's completed?
Yeah, I would prefer whenever it's completed, just in case. But yeah, that's perfectly fine.
All right, I'm going to make a motion here that this one be sent for more investigation and then report back to us, because there's a lot of missing pieces and answers here, in my opinion. So that's my motion.
I'm going to second that, Mr. President. But it was, a recommendation for a penalty and could give them 30 days. And I don't know if it needs to be a full investigation. I think maybe a little follow up. First of all, see if the family's got it, or with the medical examiner, they may can give us the, there's 3 sides to the story. Theirs, and the truth. Maybe we can find out if they have it, if they have investigated it, done a chart review, and then when we come back, I think we can make a final decision in October. So I'll second that motion.
All right. So I made the motion to have legal go back with investigation, find out more details for us. Seconded by Mr. Lee to report back at the next opportune time when that's available. Any further questions or discussion? If not, all in favor say aye.
Aye.
Any opposed? All right, we're moving along to number 10.
Number 10 is complaint number 2023-032901. Complainant, son of the deceased, stated that their father passed away on April 12, 2023, and that they had retained respondent to provide services. Complainant claimed that when he and his two aunts arrived at respondent establishment, the part owner and funeral director of respondent establishment brought up cremation as an option, stating that the funeral is over $8,000 or more. Complainant stated that he felt forced because respondent mentioned cremation repeatedly. Complainant also claimed that respondent assumed the decedent did not have insurance because of the presumed finances of the family. Respondent replied stating that during the initial meeting with the family, he asked all the usual questions about insurance the decedent may have had. Respondent stated that the family thought the decedent may have had insurance, but were not entirely certain. Further, the family was unsure who the beneficiary might be if the decedent did have insurance, was not sure whether it was over 2 years old or not, and as respondent stated, basically did not know anything about the policy for sure. Respondent offered to the family to put the decedent in the cooler while they figured out the finances, which the family agreed. Respondent stated after a few days, the family returned to make arrangements, still unsure if the insurance was good or of any other pertinent information. Respondent stated he mentioned cremation as an option because that was a more cost-effective option. Respondent stated the family ultimately chose cremation because that is what their finances would allow, and that he discounted the cremation to provide further help. The family paid the first half on April 18, 2023, and the second half on May 2, 2023. During their second visit, an employee of respondent establishment asked whether they had determined anything regarding the insurance. Respondent stated the employee was told that the insurance was not good. Respondent apologized if they had done anything to upset the family, but maintained that they remained professional throughout the process and offered more cost-effective options since it appeared that the family had difficulty obtaining the proper insurance information. Based on the above, complainant has not articulated any violation of applicable statutes or rules. Therefore, we would recommend closure.
Move we approve council's recommendation for closure.
Second.
All right, I have a motion by Mr. Berry to accept legal's recommendation of closure, second by Mr. Lee. Any further questions or discussion? If not, all in favor say aye. Aye. Any opposed? All right, moving along to number 11.
Number 11 is complaint number 2023-036931. As you all know, I'm usually good for at least one novel on these reports, so here it is. Just as a quick note, this case involves a respondent who received a 12-month funeral director's license suspension, which began starting May 1st, 2023. Complainant alleged that respondent had violated the consent order, which stated that respondent would not conduct licensed activity for a period of 12 calendar months. To support their accusation, complainant stated that respondent had continued to reside in their apartment attached to the funeral home and alleged that respondent had been seen on the grounds of the funeral home, worked in the flower beds surrounding the establishment, and officiated services. To support their claim, respondent attached an obituary stating that respondent was officiating, pictures of respondent at the establishment location, but not performing licensed activity, and social media posts that indicated respondent was continuing to live in the apartment attached to the establishment. Due to the nature of the allegation, this case was sent for investigation. The investigator arrived at the establishment unannounced on August 8, 2023. The investigator did not observe respondent on the premises. The investigator spoke first to an employee of the establishment, a licensed funeral director, and embalmer. The employee stated he was aware that respondent's funeral director license had been suspended and provided that since that suspension went into effect on May 1st, 2023, respondent had not worked in any capacity at the funeral home. The employee stated that respondent does mow the grass around the funeral home and attached apartment because respondent lives in the apartment connected to the funeral home. The investigator also inquired about respondent's involvement with the decedent who listed respondent as officiating the services. The employee stated that the decedent and respondent were friends and that the respondent often looked after decedent because of their serious health conditions. The employee stated he was aware that the decedent had asked to preach at their funeral. Next, the investigator spoke with another employee at the funeral establishment, a licensed funeral director and pre-need sales agent. The second employee stated she was also aware of respondent's suspension. Second employee confirmed that respondent had not been compensated by the establishment since their suspension. Second employee stated that while respondent does live in the apartment connected to the funeral home, respondent does not come into the funeral home unless it is absolutely necessary. The second employee further stated that respondent does mow the grass around his apartment and funeral home, but to her knowledge, respondent is not compensated for mowing the grass since he lives in the apartment attached to the establishment. Regarding the decedent, respondent officiated the services for, the second employee confirmed that the decedent and respondent were friends, and when the decedent made pre-arrangement funeral plans, the decedent requested that respondent speak at his funeral. The second employee further provided that respondent did preach the graveside service at the cemetery, but respondent came in their personal vehicle and was in no way associated with the funeral establishment nor compensated by the funeral home for preaching at the graveside service. Third, the investigator spoke to the manager of the establishment. Manager confirmed he was aware of respondent's suspended license and that he informed all staff members of the establishment of the suspension and advised the staff that respondent was not to work for the establishment in any capacity. The manager stated his wife was the bookkeeper of the establishment and that she had removed respondent from the payroll and respondent had not received any compensation since the suspension. The manager also confirmed that respondent did mow the grass around the apartment and establishment, but was never asked to do so by the establishment and was not compensated for mowing the grass. Next, the investigator spoke to the owner of the establishment, who was also aware of respondent's suspension. The owner confirmed that respondent had not worked at the establishment, nor had he been compensated since the time of the suspension. The owner explained that it had been a long-standing policy of the funeral home to have someone live in the apartment as a safety precaution and to have a presence near the funeral home after hours. The owner provided that oftentimes the tenants in the apartments were not associated with the funeral home in any way. The owner again confirmed that the respondent did have a garden outside their apartment and did mow the grass, but that they were not compensated for the mowing of the grass in any manner. On August 14, 2023, the investigator spoke to respondent. Respondent stated they had not worked at the establishment in any capacity since the suspension, and that he had not worked any visitations, made funeral arrangements, or worked any funerals. Respondent also provided he had not been compensated in any manner since the suspension. Respondent provided he had obtained full-time employment unrelated to the funeral industry. Regarding the decedent for which he spoke at the graveside service, respondent explained he was a close personal friend of the decedent and that he had spoken at the decedent's wife's service years earlier. Respondent stated that when the decedent discovered they were dying of cancer, he contacted respondent requesting that respondent speak at his funeral. Respondent provided that he did speak at the graveside service, but that he drove his own personal vehicle to the cemetery and confirmed he was not compensated by the funeral home in any way. Further, respondent confirmed he had a small garden at the funeral home he had been maintaining since 2019, and that he often mowed the grass surrounding the apartment and funeral home, but explained he had never been asked or compensated for the mowing. Finally, respondent stated he fully understood the terms of the consent order and that he would in no way violate the terms of the suspension. As proof of employment, respondent even allowed the investigator to photograph his employment badge. Finally, the investigator made numerous attempts to contact the complainant in several different ways, including but not limited to driving to the address provided on the complaint. The address led to a vacant lot. Confirming with the local 911 system that there was no address listed for the provided address. Asking the local 911 system to look up the name of complainant, which led to an old address that was not current. The investigator went to this address and spoke with the resident, who informed him he had never heard of the provided name and that he had lived at that residence for over 8 years. Sent email correspondence to the provided email that bounced back stating the email address was not valid and no phone number was provided. Based on the above, there is no evidence that respondent has continued employment with the funeral establishment or conducted licensed activity during the period of his suspension. When combined with what appears to be a fictitious complainant that intentionally provided false information, and in the original complaints that led to respondent's original license suspension, the complainants also provided incorrect contact information. We recommend closure as there is no proof that respondent has violated the terms of the consent order.
Right. First of all, thank you for your detailed investigation. I'll make a motion right now that we accept that for closure. It's ridiculous that we have to spend our time on that for a fictitious complainant.
Second.
All right. I have a motion by Mr. Lee to accept legal's recommendation of closure, second by Ms. Stevens. Any further questions or discussion? Not all in favor say aye. Aye. Any opposed? All right. Number 12.
Next is complaint number 2023-034171. Complainant stated that on or about June 14th, 2023, they contacted respondent to obtain a death certificate for their complainant's mother. Complainant claims that respondent informed them they would have to check with another family member to see if providing a death certificate would be okay. Complainant stated they informed respondent that their mother was married to the decedent. Complainant stated that on June 19th, they were able to pay for 5 death certificates and then picked them up on June 23rd. However, complainant stated that when looking over the certificate listed the spouse as unknown. Complainant stated they called the establishment to get this corrected, but were told that the other family members would either have to sign an affidavit to have the information changed, or that they would need a court order. Complainant alleges that respondent knew the name of the decedent's wife and intentionally falsified the death certificate by stating the spouse was unknown. Respondent replied stating that on June 13th, 2023, they met with the 3 children of the decedent to finalize their father's funeral arrangements. Respondent provided that when she began asking for the death certificate information and got to the question about marital status, the 3 children stated the decedent was married but separated. Respondent stated they asked for the surviving spouse's name, but that the informant, who complainant referenced in their complaint, told respondent that they did not want her on any part of the death certificate. Respondent explained to them that she would still need it for the death certificate if they were legally married, but that the 3 children said no and refused to provide that information due to family issues. Respondent stated because the children refused to provide the information after many attempts and much discussion, they had no choice but to put unknown. Respondent stated that during this arrangement conference, they printed off a draft of the death certificate with marital license listed as unknown, and the informant signed it for approval. Respondent stated the following day, they spoke to complainant regarding obtaining death certificates for complainant's mother. Respondent stated that it was not until this conversation that they learned the name of the decedent's spouse. Immediately after this call, respondent called the informant and received permission to update the spousal information on the death certificate. Respondent stated that while still on the phone with the informant, they logged into Verizon to change it, but it had already been released from the system. Respondent updated the informant saying that an affidavit would need to be provided in order to correct the affidavit. Respondent provided that as of August 8th, 2023, the informant had signed the affidavit and it was sent via UPS to Tennessee Vital Records. Based on the above, it appears respondent only included unknown on the death certificate due to the lack of cooperation from the children of the decedent. Further, respondent appears to have gone through great lengths, some of which have been omitted from this write-up in the interest of conciseness, to correct the death certificate in a manner that was acceptable to all parties. However, although the family refused to provide the specific information regarding the wife of the decedent, respondent knew or should have known that the marital status on the death certificate was married. So based on that, we would recommend a letter of instruction.
I feel like the funeral director didn't do their part here. We all, as a funeral director, if that's brought to our attention, we do have a choice to say we can't go forward until that's produced. Also, they should have gotten a release from the spouse to say the children have the right to make the arrangements. So it's almost deceptive and not clear here that the director didn't do their part, in my opinion. To your knowledge to this date, has that been provided to you, the legal, that death certificate has been corrected?
It has not, but in that timeline,
Have enough time since August 8th.
Yeah.
it seemed like, and I will say, again, from an attorney not knowing what it's like, in all of your shoes, I guess my impression was that they were put in a difficult situation where could they have done something else? It definitely seems like it. But once they had the information and it was in their hands, they laid out, I think, probably a 15 bullet point timeline of here's all the hoops I've jumped through since I got that info I needed. I convinced the informant to sign the affidavit to okay the approval when they didn't even want to share the information with me the day before. It's just, it seems like I agree. Definitely a mistake on that front end when put in kind of what seemed to me be a difficult spot. But if I had been the complainant seeing that timeline, that's what I would have wanted to see from a funeral director trying to fix it. And again, I understand you all don't have the timeline in front of you to see that. But
Now, the original death certificate, status was married, spouse name unknown, or was marital status unknown?
my understanding is that marital status was put as unknown.
See, that again right there is false, because the director did know that the decedent was married, but didn't do due diligence to get a name.
So the actual children told him he was married, but refused to give a name.
Correct.
I mean, I can understand. I mean, I know it's 50-50 to me. I can understand you got folks pulling it both ways and giving you a lot of information. Got a clean disciplinary history. All feeling more than a letter of instruction.
I am.
I agree. It's an issue that if they knew the next of kin was a spouse, and they're the legal next of kin, they didn't get any authorizations or due diligence to try to locate them, or that's a problem.
I'm going to step out here and make a recommendation to change this to a $500 civil penalty, including a letter of instruction going forward.
I'll second.
All right. Motion to change legal's recommendation to a $500 fine with a letter of instruction, second by Ms. Haynes. Any further questions or discussion? If not, all in favor say aye. Aye. Any opposed?
Aye.
All right, let the record reflect Mr. Lee opposed. All right, moving along to number 13.
Next one is complaint number 2023-035801. Complainant alleged unprofessional conduct on behalf of respondent. Specifically, complainant stated that they had communicated to respondent that they wanted to receive a DNA sample from the decedent prior to his cremation. Complainant contends that respondent said that he would, but ultimately forgot to do so prior to cremation. Respondent stated that to their recollection, which they admit may be slightly fuzzy since they first received the call regarding the decedent September 26, 2022, the decision regarding the DNA samples were made during arrangement. Respondent stated that from their recollection, it was due to an issue involving paternity, and that's why complainant wanted the DNA sample. Respondent stated that the cremation for the decedent was completed on or about September 28, 2022. Respondent stated it was not until April 5th, 2023, when they received a call from the sister of complainant wanting to know if they had taken the DNA samples. Respondent stated they admitted that they had forgotten to take the samples and apologized to her. Complainant submitted a rebuttal stating that the requests for DNA samples were not for a legal dispute involving paternity, but because they wanted to submit their DNA to a family genealogy service. Complainant explained that it was just to satisfy a curiosity as they planned to purchase the service for the decedent for Christmas, but that the decedent had unfortunately passed away before then. Complainant confirmed there were no issues regarding paternity. Finally, complainant shared that they did not realize that filing a complaint would lead to such a formal process and only wanted respondent to acknowledge their mistake regarding the DNA sample. In a conversation with legal, complainant stated that respondent's acknowledgement of their mistake in their response was validating and was the only resolution that they hoped to receive from the complaint process. Based on the above and based on complainant's perspective, we would recommend closure.
Move we approve council's recommendation of closure.
Second.
We have a motion by Mr. Berry to accept legal's recommendation of closure, second by Ms. Stevens. Any further questions or discussion? Not all in favor say aye. Aye. Any opposed? All right, move along to number 14.
Next is complaint number 2023-036241. Complainant stated that they had asked respondent for a copy of a blank contract for an irrevocable pre-need trust funeral contract, and respondent stated they could not do that unless the contract was filled in with their information and that they didn't circulate blank contracts. Complainant explained that they lived in Texas and that they were trying to get a contract for their brother who resides in North Carolina. Complainant stated that they requested the contract because they need to see what they're agreeing to and paying before committing thousands of their brother's funds towards the pre-need contract. Respondent replied stating that they had spoken to complainant on or about March 1st of 2022, who explained she was looking to purchase funeral services for their brother who was living in North Carolina, but would be buried in Tennessee. However, before complainant purchased items, she wanted to submit the contract to the state assistant's office in North Carolina where her brother would be applying for benefits to confirm eligibility. Respondent stated they explained to complainant that they could not provide a blank contract because it would cause confusion if the contract was backfilled, and that it might be more convenient for complainant to select a provider from the same parent company in either North Carolina or Texas, explaining that she could select the goods and services desired at the time of need, and an intercompany transfer could change it to the Tennessee location for services. Respondent reiterated that they were not trying to be difficult with complainant, but that they were not entirely comfortable providing a blank contract to a potential customer. Furthermore, complainant stated that they primarily use insurance-funded contracts for pre-need, and that they are not permitted to sell an insurance product to a customer whose residence is in another state. However, respondent stated they recently learned that they have access to pre-need contract through a trust agreement, and stated that if the complainant would like to select goods and services for her brother's pre-need, they would be happy to provide her with an unsigned contract to submit to the State Assistance Office in North Carolina rather than an entirely blank contract. Based on the above, we would recommend closure.
Motion to accept council's recommendation.
All right. Have a motion by Mr. Lee to accept legal's recommendation of closure, second by Mr. Berry. Any further questions or discussion? Not all in favor say aye. Aye. Any opposed? All right. Number 15.
Number 15 is complaint number 2023-029191. This complaint was administratively opened following a routine inspection conducted on June 5th, 2023. During the course of the inspection, the inspector determined that the manager of respondent establishment was the only licensed funeral director employed by respondent establishment. On March 2nd, 2023, the manager resigned from the position. As of the date of the inspection, the department had not received paperwork necessary to appoint a new manager for the establishment. The representative for the respondent establishment indicated that the paperwork for a new manager had been submitted 3 weeks prior to the inspection, but the representative was unable to produce it. Respondent replied, attaching to their response a check payable to the Department of Commerce and Insurance, dated June 13th, 2023, for the required fee for the application for change of establishment manager. Legal examined core and determined that this check had been processed as of June 23rd, 2023. Likewise, respondent also attached a copy of the application for change of manager, notarized as of July 24th, 2023. Legal examined core and determined that the document was received by the state as of July 25, 2023. Based on the above, although the department has now received everything needed for the change of manager application as of July 25th, 2023, respondent was in violation as of March 12th, 2023, 10 days following the resignation of the manager, up and until July 25th, 2023, resulting in over 4 months of improper paperwork regarding the change of manager application. Based on that, we'd recommend a $500 civil penalty, authorized via consent order, and a formal hearing if necessary.
Feel like that would have ever come up without the inspection?
Probably not. I definitely cannot say for certain, but I do think that this respondent probably needed that formal finding and nudge to get it in.
Normally stated like how many families they served or contracts, or was that in there? Did I miss it?
To my recollection, it wasn't. I can double check that.
Almost pushing 5 months with no license.
License at all. Typically, do you have to do an investigation to determine how many services were conducted, or?
I know that comes up sometimes, and this one it wasn't. That information isn't included. Basically, pretty much everything that the inspector found was included in this write-up. So don't have information on how many contracts they may have serviced during that time. But I guess I will say it is a little different in that we usually see those numbers of contract service when your license is out. And here it was the change of manager, which still its own problem. That is still very much a violation and a problem. So I think that's probably why we don't have that information, since it was for a period of time when there was not a licensed manager in place of the establishment, as opposed to when the establishment itself was conducting business without a license.
License,
He was, yeah.
only
Right.
a licensed person, period, there, so.
I'm not correct. You've got to send that in within 30 days.
I believe it's 10 days after
10
the
days,
change of
okay.
manager.
I knew it was somewhere in that window.
So yeah, I think I mentioned it in the write-up of their day one of their violation was March 2nd. So we'll say March 13th is when their 10-day window passed, and it took them a while to get everything in. And it was when everything had been received and processed by the department. It was July 25th when all that came in.
Just seems to be consistent with the past that if you had someone operating with a valid license and conducting services, that it's been a more severe penalty. So I would really be interested in
the
knowing
past.
if they conducted business during that time period. I guess it'd make a difference if they didn't have one single case during that time period and didn't conduct a funeral and they didn't have a license. It'd be different if they had multiple services with a non-licensed funeral director.
Regardless, they're
So I guess the main thing is, from what we have, the information we have available to us is that when the inspector went there was no evidence of unlicensed activity. What we have heard is the case, though, just, how that goes, hearing it through the grapevine, there's nothing that an inspector or any of us can attest to, but that during that time they were purportedly referring people out to other establishments. I truly do not know how much or how little business this establishment conducted during that time. And I would say that, unfortunately, with what we have, we just don't have that information anyway. So I guess I would encourage just generally that look at the violation of this over, I'd say, close to 4.5 months of not having a manager in place, the correct documentation of a manager in place. That, without question, is a violation.
feel like 500 is sufficient here.
I will say I struggled with attaching a penalty number to this. I think, generally speaking, kind of like we talked about earlier, when we see our month of establishment licenses, we do $250. If they service a lot of people or if it's an extended period of time, we might bump it up to $500. Not having a manager in place, I would say, if I absolutely had to rank the violations, is not quite as bad as unlicensed activity, but 4.5 months is a long time to not have that together, especially in light of, you're supposed to have it done within 10 days. So I thought 500 was a kind of a good mid-ground, all those things considered. But as always, if you all feel that it should be higher with all of that context and information included, then, absolutely.
Questions or discussion?
I'll
It
make-
could be. Go ahead.
No,
You-
I was just going to go ahead and make I know normally when a license expires, we do $250. This is $500, but you can chalk it up to not knowing if he did one funeral or 50 funerals in that period of time. But it's kind of twice of what we normally do. But there's a lot more that he could be fined for if there was nobody licensed on the premises. Him being the only licensed funeral director. I'll make a motion that we accept the council recommendation of $500 civil penalty.
Second.
All right. I have a motion by Mr. Lee to accept legal's recommendation of 500, authorizing via consent order and formal hearing if necessary. Second by Mr. Berry. Any further questions or discussion? All right. If not, all in favor say aye.
Aye.
Any opposed? All right. Mr. Bryant, anything further from you, sir?
Not right now. You all get a double dip from your board attorney today with the sunshine presentation. But as far as the legal report goes, that's all I've got.
Let me say thank you. That's a lot, and I appreciate your effort
As
on that.
always.
Absolutely. Thank you.
All right. We're going to turn to Mr. Gribble for our Executive Director's Report. Good morning, sir.
Morning. Thank you, Mr. President and board members. First on their agenda is the sunset hearing report from her July 19, 2023 appearance before the members of the Commerce, Labor, Transportation, Agriculture Joint Subcommittee of Government Operations. That's a lot to say that the board was sunsetting, which means in order to get new life, we have to appear before the subcommittee on the joint government ops, and they make a determination as to where the board gets new life. First of all, I want to thank Ms. Pam Stevens for coming on and going with us because they wanted a board representative to be there, and she graciously agreed to do that. We appreciate that. Mr. Bryant was there. Alex Martin, Assistant Commissioner, was there, along with some of our legislative team, and I was there as well. We got asked several questions. Ms. Stevens or Mr. Bryant may want to talk about those later, but most of those questions that were asked actually were questions that the Department of Health could answer, and not things that they were about funerals and funeral directing and things like that, but not specifically items for the board to address. There were items for the board to address, and Mr. Martin, Ms. Stevens, and I addressed those questions and answered those questions for the subcommittee. And I'm pleased to report that the recommendation, and how that works is they make a recommendation, and then later on in January when they reconvene, there'll be a bill that will actually authorize a continuance of the board. But the subcommittee recommendation was for 6 years, and 6 years is understanding is it longest to give 8 is a little. Sorry, 6 years is a good amount of time. It's I was pleased that we were able to receive a recommendation from the subcommittee for a period of 6 years.
Mr. Gribble, right there, I would like to also publicly thank Ms. Stevens for stepping in on my behalf of my absence with a family emergency and stepping in for me. I do appreciate that as well. And Ms. Stevens,
If you
would
have
you
any
like
comments
to?
you want to make
Yeah.
while we're talking about the sunset hearing?
It was an honor to be there, and it was a very educational process of what the legislators were asking. And as Mr. Gribble has said, they were more questions that the Department of Health could relate to as opposed to what we were actually there for. So I would encourage each and every funeral director to get with your legislator and educate them a little bit more on what we do and how the health department and the board can work together, or funeral directors can work together in the future.
And in your documents today is a one-page, what I'd call a one-page summary that we provided an additional 19-page document to answer their questions that they posed to us ahead of time, and we turned that in advance. But I know Mr. Berry talked about it would be helpful to have kind of a longer look at than we do a month by month, and this does like the complaints received. It shows the variance between fiscal year 2019-2020, which we had the fewest number of complaints we received was 68, and then the highest number being during the 2020 and 2021 of 123. So when we get the final count for the fiscal year, it just ended June the 30th, this will be the highest number because it's 121 as of June 25th of 2023. And then also there's a number of people that are currently licensed and registered. Kind of gives you a look at that. to where you can see what that is, as well as the financial information that's there. And another thing, I was very, very proud. The time we went to Government Ops Committee, Mr. Naylor had already been appointed, so we were able to go without having any vacancies or any people serving on expired terms. And as we sat there and listened to other boards, that's an important thing, that all your board seats be properly filled. That's one thing that they had first and foremost on their mind. They did ask us questions about, I guess, two particular questions that I remember and recall was about, are there any directors from, how long's it been? And if not, how long's it been? And then also regarding corporate firms, there was a question regarding maybe multiple people from same corporations. But we answered those, provided information. Mr. Bryant provided some follow-up information about the complaints. They had some questions about who the complaints were from, what type of complaints they were, and he provided that follow-up information. But again, I'm very pleased that we got a 6-year recommendation. We'll see when the bills are introduced, and once it's passed, then that makes it official. So another thing I think that you'll be interested in is this conference report on the National Board Exam Statistics for January 1, 2023 through June 30th, 2023. First, I want us to look at this is all the exams administered by the conference for the National Board exams. You'll see on the arts side, the funeral side, there was 835 first attempts, and they had an average score of 78. 657 of those, or 58.7, passed the first time with an average score of 79, and 178, or 21.3%, failed with an average score of 72. On the science side, for the embalming part, there were 792 first attempts, an average score of 76. 539 of those, or 68.1%, passed with an average score of 79. 253 failed on the first time, which was 31.9%, with an average score of 71. And then what I think would be even more of interest to you is we have two colleges in the state of Tennessee that are accredited by the American Board of Funeral Service Education. One of them being John A. Gupton College here in Nashville, and you can see the statistics there. 39 first attempts on the arts side, an average score of 81. 39 passed that with an average score, so they had a 0 failure on their arts side. On the science side, 41 first attempts with an average score of 79. 37 or 90% of the individuals passed with an average score of 80. 4 or 10% failed with an average score of 74. Of course, 75 is passing. So those 4 people made 74. And then it breaks it down into the different components and subjects, as you can see that. The other mortuary college in Tennessee is Southwest Tennessee Community College in Memphis. It's not been in existence for too many years. It is an accredited college by the American Board of Funeral Service Education, so they don't have the history that John A. Gupton has. But on the arts side, there were 2 first attempts, an average score of 74, 1 passed and 1 failed, and there were 0 attempts on the science. So I thought that would might be helpful for you to see that and to see how the 2 colleges were performing in Tennessee. If I recall correctly, there are 54, 56 mortuary colleges across the United States that are accredited by the American Board of Funeral Service Education. On the second page, or the next page, is just some conference initiatives that have been taken since February of 2023. You can happening been a concentrated effort for the conference to work more closely with the National Funeral Directors Association and the National Funeral Director and Morticians Association, because as we all know, there is not enough funeral directors and embalmers to fill all the positions and all the need. And I think everybody's concerned about what can we all do, what can we get together and do and make it to where people get involved, where they get their education, they get licensed, and then where they stay in funeral service, because you also see a lot of surveys where people are exiting after 5 years. A large percentage of people are leaving funeral service. So that's, just thought it'd be helpful and interesting to you to probably know that and know especially about our two colleges here in Tennessee. Next is the licensee report. It's a report of licenses administratively approved by the executive director pursuant to the board authority for the period of June 10, 2023 through August 23, 2023. And of course, it's been longer than normal since we've had a board meeting, so that list is longer than normal. Next, closed establishment report, and we have no closed establishments to report to you since the last board meeting. Next would be the disciplinary action report. This is a report of consent orders that have been administratively accepted and approved by the executive director pursuant to board authority, and as reported on the May, June, and July 2023 regulatory board disciplinary action report. List of those violations were Ashley complaints, 14 related either to or embalmers, and 16 related to establishments. So we have 30 as far as that number. That concludes my report. I'll be glad to answer any questions you might have.
I'd first like to say congratulations to you and Ms. Bohannon and all of you that work in that office for getting approved for 6 years on the sunset hearing. We appreciate all your hard work.
We accept the director's report.
All right, we have a motion by Mr. Berry to accept Mr. Gribble's executive director report. Do we have a motion? A second. Sorry. Second by Ms. Haynes. Any further questions or discussion? All in favor say aye. Aye. Any opposed? All right. Do we need a break as a board before we go into these individuals, or is everybody okay? All right.
First, I will need to recuse myself during the applicant's portion.
Okay. So let the record reflect that Mr. Berry is recusing himself from the applicants that are appearing today.
Which one is going
Are you
to be
doing both? Okay, yeah, he's recusing from both. And Mr. Gribble, who do you have that would appear first? I know we have two. Does it matter which?
We typically put them on the agenda in alphabetical order, if that's okay with the board. The first one is Circle of Life Cremation, LLC. The manager would be Jennifer Sutherland. It'd be located at 10127 Chapman Highway in Seymour, Tennessee. It is a new establishment. Its ownership is a limited liability company, and its owner is Circle of Life Cremation, LLC, there in Seymour. So, Ms. Sutherland, or you and your husband, whomever wants to speak on behalf of the proposed establishment, just come up here and get the information that you want, your opening remarks to the board, please.
Good morning, Ms. Sutherland. If you will, just address the board and tell us a little bit about yourself and your location here.
Jennifer Sutherland, and thank you very much for having me today. Obviously, yes, as he said, my location, 10127 Chapman Highway. I am in a very triangle
We'll just step up and speak a little closer there.
Sorry.
There you go.
But that is all I have to say. Thank you.
Board members, you do have Ms. Sutherland's application before you, and we will open the floor for questions for Ms. Sutherland.
Good morning. It's my name is Pam Stevens. How long have you been a funeral director?
I was licensed June of 2013.
Very good.
Yeah.
Looking over your application, so there is no pre-need to be written at this location, or maybe in the future.
Well, I'm a life producer, and yes, I will be writing pre-need, but not until I choose an insurance company.
Looking also over the application, am I seeing this correct? You're only going to be offering cremation only, is that correct?
That is correct.
Okay.
If a family does come to you for traditional funeral service, what would be your plan?
Well, I would have to refer them. I'm not offering. I'm not offering. No, right now I'm not, but I'm not offering immediate burial. Right now I'm offering only direct cremation.
So if a family wanted to have a private viewing of their loved one, I noticed you've got minimal prep in here and things like that. Where do you plan for those things to take place?
If they wanted to view, they would be viewing at the crematory, privately at the crematory.
Do you have pictures? Yeah, I see it now.
As far as paperwork and the inspector and all that, was everything in order as far as what the requirements are through this office?
Yes, as far as we know, there was a follow-up on some price list information that the inspector did, and that was submitted and revised. And as far as we know, everything paperwork-wise is in order at this time.
So another question I would have is, maybe I'm looking at this wrong, but who do you have set up to do the transfer of the decedents to, like, places of services and things like that?
Mike Harding, Blunt Mortuary, will be doing the removals and the transfer directly to the crematory.
Once they have the decedent in their care, they're going to take care of all of that for you. You won't be handling that part, is that correct?
No, I will not.
Okay.
Yeah, they will go directly to refrigeration at the crematory.
You have some form of ID
I will.
that you will do yourself?
Yes.
Okay.
With the pictures that have been submitted, what room would the identification be provided in? Is it the room with the?
That would be a crematory, right?
No. Yes.
But this is
no deceased are coming to my location. They are going directly to refrigeration at the crematory. I would be going over to the crematory to identify the family. If they wanted a private viewing, that would also be at the crematory.
Do they have a private room there, or is that more of a open type area?
It's an open top area.
I'm so sorry. What crematory are you using? Oh, Little
Brook Cremation Company in Maryville.
Okay.
Have any pictures of that one? That's what I'm struggling to find, of the crematory.
There's not any
inspection. I didn't see any
photos from the
pictures.
crematory included.
And you're sharing this with this building with a mattress company, is that correct? Their storage area?
Okay, so yes, the basement of this commercial property is a mattress storage only, and that's truly all it is.
Okay.
Just storage. There's even went so far as to speak with the leasing company about any electricity. They don't have HVAC down there. There's no air conditioner down there. It's truly just storage.
Does the crematory you're using have more of a private viewing area, or is it all open? I think that's where I'm struggling
Okay.
with this.
Yes, it is open, and when a family is wanting to view, I have spoke with the crematory about this, and it takes place there right there in the garage area of the crematory. Not necessarily that. There's no one else there. They schedule a private viewing privately. There's not another family coming in, but that is it. Yes, sir.
I just feel like families deserve more than that, in my opinion.
Can you visually walk me through when, let's just say I'm a family member wanting to say my final goodbyes to my loved one. I walk into a crematory. Is the retort right there, or is there, as Mr. Harris was alluding to, a private room, and then you walk into another area, and then there's the retort.
Okay, so when you walk into it, the retort it's very large. Okay, it's very large there. First to your left is going to be refrigeration. You continue a little bit, then you're going to have the retorts. But the area behind the retorts and then the offices well over here, it is a very large area. So I understand what you're saying, but I have went through this with them, and that is what they tell me. That is where a family views.
Okay, behind the retort, is that a separate room?
No,
or it's all one big room?
That is correct. And I don't want, when I say behind the retort, I don't necessarily mean right there at the retort. I'm not saying that. But yes, in that big open area.
So it's all in that one garage compartment, is what you're saying?
Yes. Yeah.
You potentially have another option that you could look at for private viewings?
I do. And that would be, so I do not right at this moment because I do not think that, but yes, I absolutely could. I could, if I knew, and not necessarily knew in advance even, but once I met with the family, if at that point they tell me they would like to view, then I could certainly make arrangements for the deceased to go to another location, another funeral home location.
That funeral home's not a letter of agreement in your application today,
No, it
correct?
is not, but it would. But yes, I could certainly do that.
Me personally, I think I would really like to see that. I just feel like families and their loved ones deserve more than a private viewing in just a garage. That to me is just very undignified. Again, that's my opinion.
As well.
I'm in agreement as well.
So, board members, what would be your take on this application? We're open for a motion here of what we do.
So what are you proposing? You gonna put her off for another month because of that, or is she gonna be able to move ahead and then work with the board trying to resolve that?
My opinion would have to be reappear to give us part of the application to where this proper viewing would take place.
But for the record, she has met all legal requirements, right?
Will you agree that that is the case?
I'll defer to legal counsel, but she's met all the requirements of her office. I'll say it that way, that I'm aware of. The application meets all the requirements of her office that I'm aware of, but Mr. Bryant may have further to say.
And I'm also not aware of any legal requirements that have not been met in regards to this application as well.
I might get voted down here, but I'm okay with the business of what you're doing. Where I'm struggling is decedents and their families deserve more than what you're going to provide. So my motion would be to give us a letter from the establishment where there's going to be a private room area, not an open garage viewing, and report back to us at our next meeting would be my motion.
So don't mean to interject, but one thing I will just add is that I think it is, especially as what I would consider to be experts in the industry, it's more than fair to have views and opinions about what might work and what might be dignified and what might be appropriate. But I guess at the end of the day, it's kind of twofold in that, there are almost two groups of people that approve these applications. One is the board, which you hit that first line. Does it pass the minimal requirements? And I would say, generally speaking, yes. The second one is public approval, that if they're not happy with the way it's set up, they will speak with their wallets and, not to put any bad energy on you, but won't succeed in regards to that. So I would just, I guess, caution kind of on the slippery slope of that. I understand what might not, you as professionals, what you might not like to see, or people who really know the industry, versus we're dealing with that first rung of what are the minimal administrative and legal requirements. And as far as I know, those have been met through this application.
So if I'm hearing you correctly, then because they meet legal, then we should vote on it as presented and see where we go from there. Is that maybe the way I'm hearing that?
Essentially, that it should be as presented, but if the board has concerns that those legal requirements haven't been met and want to give the applicant more time to get those together, then that's perfectly okay. But I guess more so of just if there's something kind of in the back of your head that's, I really don't like the way this is going to be done, if it still kind of clears that legal administrative hurdle, then I guess that's something that's left to the board of public opinion as to whether that's a deal breaker for them.
Even though there's a motion on the floor, may I continue asking a question?
Please.
I know you said you got your license back several years ago. Did you work for a funeral home, or have you always worked for an alternative cremation type industry?
No, I worked for Evergreen Services from 2012 to 2015, and I was manager at Woodhaven Funeral Home from 2018 to 2021.
That's in East Tennessee. I'm Middle Tennessee. Is that
okay? Tullahoma Funeral Home is in Middle Tennessee.
Tullahoma?
Uh-huh.
Oh, okay.
And Woodhaven Funeral Home is in Powell.
Okay. Okay. Well, I do think Mr. Bryant has a point that the public will make a decision on whether or not they will use your facility. It is the responsibility of this board to make sure that we take care of consumers and the family members. In some cases, this one specifically, our hands are pretty much so tied because of the legal situation. I don't know how this board would feel about delaying that you provide some sort of dignified place for people to go to. But again, I think our hands are tied, Mr. Harris.
I have my motion there. We'll see if anybody seconds that. If not, we will step back and punt. Is there a second to the motion? All right. There's not, so we will open the floor for further motions.
Based on what was presented and having met the obligations required by the office. And, I've thought of this before. There's a lot of things I like, don't like, traditional, non-traditional. But until we change that at a higher level, we're here to make sure when they come before the board, they've met every obligation that we require of them. So my motion is to approve the license for Circle of Life Cremation, LLC.
I have a motion by Mr. Lee to approve Circle of Life Cremation for licensure. Is there a second to that motion?
Second.
All right. I have a second by Mr. Porch. Any further questions or discussion? All in favor of approval, say aye.
Aye.
All of those that do not approve, say aye. Aye. All right, so we're going to have to take a head count. All those that were nay, raise a hand.
Roll call vote.
Roll call. Let's do that.
Roll call.
Ms. Bohannon, please.
Anthony Harris,
No.
Tanya Scale-Haynes,
No.
Chris Lee,
Yes.
Wendell Naylor,
No.
Scotty Porsche,
Yes.
Pam Stevens.
Oh,
So, Mr. President, there were 4 noes and 2 yes.
Right, so the approval does not go through. All right. So I guess going forward, we would ask that you review that and take some of our recommendations and maybe get with Mr. Gribble, have that brought back to us for reapproval.
Just a question, so that
Yes, sir.
if that's a denial or how to word it, we need to know whether to deny the application in our system and whether there would be a new application process or whether this would just be to continue the application. Mr. Brown, I may need some help in wording this, but to continue it and then submit additional documentation for it to be brought back to you to later.
My opinion, I'll speak for me. I like that. I think we leave the application open, but I think we're asking for another alternative to be represented. Other board members, you're welcome to speak on that, but that's my opinion. Other opinions or thoughts?
I agree with you. I agree with Mr. Harris.
I agree with Mrs. Stevens because we are here to protect the consumer. So there should be another alternative brought to us as far as the viewing.
Sutherland, we want to encourage you to be in this industry and to be an owner in your own company and provide great services. Please understand this is only to enhance your career and to help
Absolutely.
the consumer in that area. But it would be great to be brought back to us some alternatives of a place for the viewing as opposed to being in a big garage with a retort. We would appreciate that.
Very well said. Yes. All right. Moving right along. Any other further questions or discussion before we move along? All right, Mr. Gribble, our next
Next establishment is Cremation Services Knoxville, LLC. The manager to be Mr. Eric Arnold Botts, to be located at 2606 Greenway Drive, Suite 322, Knoxville, 37918. It's a new establishment. The ownership would be a limited liability company and would be Cremation Services Knoxville, LLC.
All right.
Muted it already. I'll be recusing myself due to a conflict on this application. For on the record, please.
All right. Let the record reflect that Mr. Lee is recusing himself. All right. Mr. Botts, welcome, and we'll let you address the board. Tell us about yourself and your new location here.
Eric Botts. I am been licensed as a funeral director since 2003. I'm a third-generation funeral director from Cleveland, Tennessee. Moved to Knoxville in 2010 and took Mountain City.
You'll speak into the mic.
Sorry.
There you go.
Stay a little close.
There you go.
Built a crematory there. Took a little hiatus out of the funeral business in 2019. I had a daughter born, and I'd just seen lots of struggles with funeral directors and their families, so I stepped out, but didn't step out for long because I missed it. So I decided to get back in as the manager of Baldwin Mortuary in Knoxville. And at the time, it was owned by Chris Mayberry and West Tennessee Funeral Associates. It then was purchased by Anthem Partners, and then was purchased again by Rodney Edwards and Music City Mortuary. This just happened this past spring. Mr. Edwards and Music City Mortuary have determined to take a different path and go back to a true mortuary service that does no business to the consumer. So they allowed me the opportunity to purchase the cremation calls, the cremation side of the business from that location. So that's why I'm here. That's why I'm proceeding with trying to file an establishment license and get my business started. I too have a suite in a professional building that's located right off of the 640 interchange at Broadway in North Knoxville. I will be utilizing the same crematory that Ms. Sutherland is utilizing, Little Brook, but my I will be picking up my own bodies. I did purchase a Dodge Caravan and a couple of cots, but as a backup to that, my relationship with the former Baldwin location, which is now called Mountain Mortuary Partners, they will be assisting me in removals. That's where I will house the bodies in their cooling suite. They do have a place there for identification viewings and family viewings. So with that, I'll
Board members, you do have Mr. Bott's application before you. We'll open for questions. In the future, will you be offering pre-need at this location?
will be in the future. I will decision probably next.
Clarify the same. You're only going to be offering cremation, no traditional. Is that correct?
That's correct, sir.
Again, we'll ask the question. The viewing would be, if a family wanted viewing, where would that take place?
That takes place at Mountain Mortuary. That's located at 914 Cherry Street. It's the former Baldwin location.
Are there pictures available for that location?
I have any pictures.
Looking over your office space here, it does share with multiple folks. Is that correct?
That is correct. It's a three-story facility. First level is a doctor's office. Second is a legal suite. Third, I share with an insurance company and a therapy practice, psychological office on the third.
Is there signage on the outside, or just when folks walk in the door, how to find you?
There is signage. I don't have any signage up yet, but there is signage on the outside that I'll post, and there's plenty of signage inside, along with an elevator.
Have your own private entrance
Yes, sir.
on that floor?
Private entrance, that's correct.
Mr. Botts, we're faced with the same situation of not being able to see where the families will be going.
Can you tell us a little bit more about the location where families would go?
Yes, when you walk in the front door, there's an administrative office and then a sitting area that has a couch, chairs, an electric fireplace. It's kind of a homey feel. It has a ADA restroom, then it has a private office, then it has double doors to the right where you step through into that's where the embalming facility is. There's an embalming room there with, you know what that was. There's an embalming area there with the cooling suite. There's a cooler that houses 8 bodies. There are 2 options. This is also the facility that I was manager at for a couple of years prior to the last acquisition. There's 2 options that we've utilized for people to do viewings in that area. One being, if we didn't have any other families or anything scheduled, we would bring the body out into that sitting area where the family could have time with the couch and chairs. The other is we bought some, I believe they call it pipe and drapery that's used in like convention centers. It's 8 feet tall, long curtains, and I bought a rectangle to where when we opened up that double doors inside the prep room, you're not walking into a prep room, you're walking into what looks like curtains, and the body is up against that, so you're not seeing the preparation table and the cooler and things in the background. So those are the options that are utilized there at that location for viewings.
I'm going to use a scenario. Let's say that I am in that front office with my loved one, and someone is just dropping by to the postman or a delivery. They're going to open your main door, and they're going to.
We would always lock the door. That was our procedure. We would lock the door when there's a family taking care of a viewing in that time.
That will still be the procedure of that location, even though you're no longer the
Absolutely.
manager.
There's a letter from application.
Yes, and it meets it on the GPL, but in my opinion, the transfer of remains you've got there to funeral home. Of course, you're not a funeral home. My only opinion would be to change that into our care. It's not going to reflect how I vote on this. That's just an opinion. That way it's more that
Understand, sir.
That decedent's not coming to you at that point. Other questions from the board?
Is this room
out of administrative offices?
That's correct. That's my lovely wife sitting at the administrative office.
Okay.
Does that suite have its own restroom, or are you sharing?
It's a shared men's and women's restroom per floor.
Other questions, or would anyone want to make a motion on the establishment that's before us?
I just have a question. Mountain Mortuary,
Ma'am.
they've agreed for you to do your viewings there?
Yes, ma'am.
And you have that, in writing?
I believe on the letter it says any services that need to be rendered. Yes.
Are the pipe and drapes, are they going to be permanent, or are they temporary?
No, sir. They're able to be collapsed and set back into a corner because we don't keep them up in day-to-day business operations. That's just if there's a scheduled ID or family viewing.
And it will cover the view of the
Floor to ceiling. Yes, sir.
wall to wall.
It's if you open up the double doors, it's the size of the double doors, probably about 6-7 feet. 6-7 feet, 6-7 feet. So yes, sir, it's completely encompassed into basically just a small little private room.
Why do you want to get back in the business?
Helping people. During the time I was out, I lost one family member, and I lost several. Some of my best friends, for instance, my best friend in the world lost his father, and I couldn't help other than just give him advice. And so this is a stepping stone for me to get back into the business. This space that I'm leasing is not permanent because I have a vision of a new facility that would be able for me to house events and not just typical memorial services, but visitations, receptions, being able to loan it out to nonprofits. That's my vision. But this is the stepping stone to get there. So that's why I'm here trying to get that ball rolling.
Mr. Harris, I would like to see Mountain Mortuary Service, pictures of that. I don't want to delay you, but I definitely want to make sure that we cover all the bases.
Understand.
I don't know how we.
You want that as a motion that we approve it and he presents that to Mr. Gribble, or is your motion for those pictures to come back and are represent?
I'm going to ask other board members for their input on that.
I think we're in the same position here as the last, unfortunately, and it's odd that we have two in the same day. I agree with you because we don't know what's there. And at the same time, we're protecting decedents and their families. So I agree with where you're going.
Mr. President?
Yes, sir.
Since there was a change of ownership recently at Mountain Mortuary, if you want to take a 15-minute break, then Miss Bohannon can probably, I don't know if she can download them to the iPad or what, but we would have some photos. Now, I don't know if we'd have all the photos that you want to see, but because there was a change of ownership when the inspector went and did an inspection at that facility.
It was in April of this year.
Okay, so Mr. Bott says in April of this year, that would be, I mean, it's not a photo from last week or 2 weeks ago, but there would be some photos included. Now, how many and how detailed it would be, it might not be detailed enough, but we could provide you with those if you want to take a break and look at those.
I'm all for taking a break right now.
If you've got those, I say let's try to take a look. Yes, sir.
The only thing they will not show would be the pipe and drape, because that wasn't necessary for photos to be made of that for the mortuary company. But it will show the office area, the reception area, the preparation area, the restrooms. I'll be happy this afternoon to upload a picture of pipe and drape as soon as I got back there if I need to. But I've been trying to get on the docket for 3 months now, so I would very much appreciate not being delayed another month, because I've been forking expenses out for 3 months.
Let's take a break and let's see what pictures we have to present, and let's make a decision from there. So we'll recess for 15 minutes. Will they give you enough time, Ms. Bohannon? Okay. Recess for 15 minutes, and we'll come back at about 6:40, or excuse me, 12:40, not 6:40. We're going to resume our meeting. It is 12:35. And Ms. Bohannon, do you have the pictures that was requested of this location? Members, they are there on our screen to our left. We'll review those together. So, Mr. Botts, if you will, just talk to us through these pictures and tell us what we've got here.
Yes, sir. This is the exterior of the facility. The main entrance is the far door to the left. If you'll scroll down to the next picture, that is the open area, couch chairs, and if you look straight ahead to the double doors, yes, ma'am, that's going to be going into the prep room. Now, we have brought bodies out of those double doors on either a stretcher or a dressing table, fully covered, right out into that area for the families. If there are going to be a few more family members other than just one or two, then this is where we do that. When we utilize this area, the front door remains locked and the phones are rolled. And then if you'll go down, preparation area, go down one more. That, if you'll see right there, not fully enclosed, but that's what the pipe and drape are. Those are basically long curtains that floor to ceiling. You close those and it covers cooler, preparation tables, whatnot.
Okay, so back up just a second, if you will, Ms. Bohannon. So you're saying this area right here with the tables, with the last picture with the curtains, that area would not be viewable?
Correct.
So where are the curtains adjacent to this table and stuff?
Those are the ones that are freestanding. They're pulled out of the corner. The ones, if you go down one more picture, those are suspended from the ceiling.
Whatever is happening in the prep room would cease if a family was in there with the pipe and drape.
Absolutely. Yes, ma'am. Matter of fact, it's such a small facility. When I would meet families in that sitting area right there, we would not, embalming would cease, boxing of bodies would cease, just because it is a small facility. You can hear through those double doors. We operations behind them.
Refresh my memory. The crematory is or is not at this location?
No, sir. We utilize the Little Brook Crematory.
That's right.
So when you go through the double doors, what will you see first? The refrigeration unit, or will you see the embalming room. So how?
Talking about if the curtains are not pulled,
No,
correct?
just period. So it's just one big open area.
It is, yes.
Okay. And so, where is the refrigeration unit?
To the right of that table. Not that cabinet, but behind. It's not in the picture.
Yes.
Do not have a picture of the fully pulled
Sir.
curtains.
Who's the owner of Little Brook Cremation Services?
Dale Hinkle.
Dale or Gale?
Dale with a D, dog.
Dale Hinkle. Mr. Potts, isn't there a Cremation Services of Knoxville already in Knoxville?
Knoxville Cremation and Memorial Services.
I'm coming from Kingston Pike and taking a right, going up a hill. There's a cremation company on the right. What is the name of it?
Cremation Options.
Oh, okay, not a Cremation Services. Cremation Options.
Yes, ma'am.
Okay, thank you.
So you will be responsible for doing all proper identifications with the family.
Yes, sir.
Other questions or thoughts for Mr. Botts?
So, if you all will bring remains from out back and basically put it in the lobby area, will the office work cease as well?
Correct. Phones will be rolled. Office work ceases.
I guess another question on that, if somebody come to the door, could they see what's going on in that room?
No, sir. I'll clarify. Each window has shutters that are pulled, and also the front door is a full glass pane, but it has one of those magnetic sliding shades that drops all the way down to the floor.
And that door right there in front of the black car.
Correct. Has a shade that drops all the way down.
Thoughts, questions, or does anybody want to move with a motion?
I have to say, Mr. Botts, that because those pictures were made available, that helped the circumstance, in my opinion. It's still, I'm an old funeral director from a traditional background, and
I am too.
It's hard, but it's very hard. But I'm going to make a motion that we approve this application.
I'll second.
All right, we have a motion by Ms. Stevens, a second by Mr. Porch to approve this application. Any further questions or discussion? If not, all in favor say aye. Aye. Any opposed? All right, congratulations. You have been approved.
Thank you.
Just a minute here. Do we have any other establishments or individuals?
So there are no other establishments and no individuals today.
All right, let me get our other two board members. Okay. All right, so we have Mr. Berry and Mr. Lee back with us. We'll move forward into our section of new business. The first thing before us, the 2024 board meeting dates have been presented to us. Is there any questions or problems with any of those dates? If not, we'll move with a motion to approve.
So moved.
Second.
All right, we have a motion by Mr. Berry, second by Mr. Lee to approve the board meeting dates for 2024. Any other questions?
I have a question. Hold on, I'm sorry. June the 11th. Mr. Gribble, I think that's in the middle of TFDA. Do we typically meet anyway?
Typically what we do is schedule the meetings the second Tuesday of each month, and then in consultation with the board president, is when, and legal is when the decision is made on whether to cancel a meeting or not, but typically set the meetings for the second Tuesday of each month.
Just want to make you all aware that is during TFDA's convention. I don't know.
Okay. Any further questions or discussion on the motion at hand for our meeting dates in 2024? Not all in favor say aye. Aye. Any opposed? All right. Thank you. All right. We are going to move to the Sunshine Law Presentation Training, Open Records Public Meetings by Mr. Troy Bryant. We'll turn that over to you, please.
All right. So you all have essentially touched on this before. It's probably been quite a while for some of you. I know we do it whenever you're first brought on board into your onboarding. So poor Mr. Naylor gets an extra double dosage of this. But just a refresher. We like to give it every year. My understanding is that maybe haven't been as frequent as that lately, but so just a refresher just to go back over it. So this will essentially be regarding the Open Records and Public Meetings Act for regulatory boards and commissions. So we could skip to the next slide, please. Classic legal disclaimer, but basically this is just for training and representation purposes. Nothing in here is legal advice or sound, absolute, abiding by black and white rules. Everything happens in a real world context, but essentially just, no guarantee that everything in here is exactly 100%, but just a good refresher course to all keep in mind while you continue to serve on the board. So next slide, please. So we'll start with the Open Records Act, which that's found in Tennessee Code Annotated Section 10-7-503. Next slide, please. So I guess the first question would be, what is included in an open record? What are open records in regards to a regulatory board? So those things are going to include pretty expansive list, documents, things like papers, letters, maps, books, media, photographs are included in that, recordings, electronic data, other materials, regardless of physical form of characteristics. Basically, as long as it's made or received pursuant to law or ordinance in connection with the transaction of official business by any governmental entity, it falls into public records. It's almost easier to tell you what is not a public record, which would be things like the devices or the equipment where those records are displayed. So your iPads, if someone put in for a public record request, they could not get an iPad. That is the device, not the record itself. But everything else, what are public records, is a fairly expansive list. Next slide, please. So this kind of combines with the Public Meetings Act, which is found in Tennessee Code Annotated Section 8-44-101. And essentially, there are going to be a couple of questions we're going to look at and we're going to hopefully answer. Public Meetings Act, which will be abbreviated on the rest of these slides as PMA. We're going to look at what is the PMA exactly, what is considered to be a meeting and what isn't, what's required for a meeting covered by the PMA, things like notice, the agenda, public presence, the minutes that you all approve at the beginning of every meeting, things like that are required. And what happens if you violate the PMA and have a meeting you shouldn't? And short answer to that is nullity, but we'll talk about that a little bit more. So the Public Meeting Act definition is found in 844-101 subsection A, and that is defined as the General Assembly hereby declares it to be the policy of this state that the formation of public policy and decisions is public business and shall not be conducted in secret. Essentially, sunshine laws, as the name suggests, everything is done out in the open, out in the sunshine. When you have a board kind of regulating such a forward-facing professional license, all of its business needs to be conducted out in the open to where anyone who wants to watch it or be part of it are allowed to be. And then that definition goes on to include in subsection B, this part shall not be construed to limit any of the rights and privileges contained in Article 1, Section 19 of the Constitution of Tennessee. So there are some, next slide, please. There are some case law that has said some things about it regarding the PMA, that it's primarily remedial in nature, and it should therefore be construed broadly to promote openness, accountability in government, and to protect the public against closed-door meetings at every stage of government's body deliberation. So basically just that in context of this Public Meetings Act, just that, it should always defer to the side of things to be open and available to the general public as much as it is possible, reasonably possible, essentially. So applying that, Tennessee Code Annotated 844-102 subsection A provides all meetings of any governing body are declared to be public meetings open to the public at all times, except as provided by the Constitution of Tennessee. So again, going back to that, just openness and invitation to the general public to be able to be a part of a meeting that is available to the public as much as possible. So what is a governing body? And luckily, which we're not always so lucky in statutory schemes, they thankfully defined it. In 844-102 subsection B1 capital A, they state that governing body means the members of any public body which consists of 2 or more members with the authority to make decisions for recommendations to a public body on policy or administration. Next slide, please. So I know it feels like very sectioned off in different parts. It'll all come together, I think. So the PMA applies to every meeting of a board or a commission. So the question then becomes, okay, Public Meetings Act, it applies to every meeting we have. Got it. Makes sense. So what is a meeting? Where does something cross the line to becoming a meeting? So the statute says that meeting means the convening of a governing body, of a public body for which a quorum is required in order to make a decision or to deliberate toward a decision on any matter. This includes committee and subcommittee meetings. So essentially to kind of, I guess, put that information together that we talked about, that it can only take 2 of you. So I've learned in my time here that the funeral director and embalming, I guess, industry is pretty close knit. People seem to know each other really well and know of people at worst, and so that if two of you were to run into each other at the store and talk about how your parents are doing and talk about how the Vols did last night, that's okay. That's you're not required to not be people or colleagues, but when you say, hey, did you see that number 7 on the legal report? That's when two individuals start talking about information that is supposed to be reserved for a board meeting. That's a meeting right there. That's supposed to be done because it's two members discussing board business, and it's not out in the open. It's in the middle of Whole Foods or Publix or wherever. So that's where you get into trouble. And it's really easy to do, and I'm sure people who have done it don't do it intentionally. But once you kind of cross that line into talking about board business with at least one other board member, and obviously that applies if there are more as well, then that's when you start running afoul of the Public Meetings Act. So with that in mind, considering what is not a meeting does not include any on-site inspection of any project or program. The inspectors cannot, in conjunction with the inspection, deliberate towards a decision. So part of that is that if there are, because as we talked about before in the definitions and statutes, part of the responsibility of these boards are making decisions. So even if it is something as small as, hey, that number 7 in the legal report was crazy, what did you think about it? Even though you're maybe not making a final decision, you're making some kind of decision that's a communication regarding board business. Things like, inspections where a deliberation or a decision isn't being made, then that doesn't trigger the PMA. So a few more examples of, let's see. Sorry, Lisa, I think I may have lost you. Or I might be going too slow. Let me see. I'm on 14. No, that is my fault. Okay, so a couple more examples. A meeting does not include a chance meeting, 2 or more members of a public body. So that's your meeting at Whole Foods. However, no such chance meetings or informal assemblages can be used to decide or deliberate public business, circumvention of the spirit or requirements of the PMA. So again, good to talk about, non-board business when you just run into each other. But if it's, hey, I'm going to be at Whole Foods in Nashville at 7 p.m. If any other board members want to happen to be there and talk about something, that's not going to work. PMA luckily is a little bit more sophisticated than that. But so again, just a chance meeting, that's okay. But once you start talking about board business, that's when it really starts to push. Additionally, okay, next slide. 2 or more members of a public body may share a meal together in which public business is not conducted. Discussion should not constitute deliberations, i.e. examining and consulting in order to form an opinion, weighing arguments for and against a proposed course of action, anything like that. So I know that board business is very exciting and it's probably all you think about in your free time. But if you run into each other, had dinner with each other, just talk about anything but that. So more examples of what's not a meeting. Lunch breaks, restroom breaks, smoke breaks, recesses between morning and afternoon sessions. I mean, the recess we had, adjournments between days of a multi-meeting. Those are not meetings. So because they are not meetings, board business should not be discussed. Essentially, it's kind of a, if it is supposed to be brought up in a meeting, definitely bring it up in the meeting whenever everyone knows it's happening, not a conversation, kind of in the middle of nowhere where the public doesn't know that meeting is happening. Next slide. So we have we have an exception, and I will say that the exception is fairly rare. So Tennessee Code annotated 844-103 A and B. That applies to both regular meetings like we're having today, and a special meeting. Both of those are going to be are going to count as meetings for purposes of the PMA. The exception is an executive session. So, next slide. We'll talk about that a little bit. Executive sessions occur when one or more members meet with the board's attorney and the board is under lawsuit or has been threatened with suit, and the members ask their attorney questions related to such suit. So that's when it kind of ceases to become a meeting and more of just clients seeking legal advice from their attorney. That's okay. That's not something that has to be out in the open. But it can't just be hypothetical of, hey, we all had this one question for you. It does have to be met with the attorney. The board has to be under lawsuit or threatened with suit, and our conversation has to be limited strictly about that suit. Again, that's one where we couldn't say, hey, while I have you, can I ask you a question about number 7 on the legal report? That conversation with kind of this very carved out and narrow exception of an executive session needs to be related strictly to active or prospective litigation. Next slide, please. The board may not deliberate about any specific matter before it or potentially before it in any executive session. So again, just restating, if we have that kind of legal-based meeting about prospective litigation, that's what that meeting needs to stay about. So how far does that go? So an Tennessee Attorney General opinion stated that oral interviews conducted by the Civil Service Commission of Maury County with persons applying for jobs within the classified service of the Maury County Sheriff's Department do come within the provisions of the Open Meetings Act. So that doesn't necessarily apply to this board, but that's just an example of how far the exception can get pushed. That the takeaway from this is that executive session exception is very, very narrow and minor and carved out very specifically. So I guess the cautionary tale there is just don't think if I'm in a conversation with you about it and you say, oh, well, I'm talking to Troy, this is an executive session, we're good. It's not unless all 3 of those elements are met, which was conversation with the board attorney about prospective litigation, and that's all we talk about and nothing else. So that's just a cautionary tale of that. Executive session is fairly rare, I'd say. Next slide, please. So here's an example. If a member emails and the chair says, hey, here's a news article, I'd like something included on the next agenda. Not, here's a news item about one of our licensees, we should consider revocation. So that second one, we're right in the thick of board conversation. We're talking about something that even, it seems like here a determination's already been made, but the PMA talks about even deliberation of just like hey, we should consider revocation. That's something that should be reserved strictly for the board meeting and the public meeting. Next slide, please. If a member emails the commission's counsel, I have a question about the legal consequences of something the commission has done. Not, I have taken an action as a commissioner and now someone is upset. Again, blurring the line of what is board activity being done outside the public gaze. If a member emails another commissioner, if you send an email or pick up the phone to call another commissioner, that is not a chance meeting. So even if you don't discuss commission business, it gives a strong appearance of impropriety and for safety's sake ought to be avoided. So chance meeting is running into each other at a restaurant or, at the grocery store or whatever. A calling up and talking about, I guess, non-related business gives the potential appearance of impropriety. It's something that I think most lawyers are secretly, I'm not because I'm terrible at math, but secretly as statisticians of, look, I know all of you, you're not going to talk about the board meeting, you're not going to talk about board business when you pick up the phone and call each other. But from an outside perspective, it can present that appearance. And those attorneys that play the odds of, you can either roll the dice, and if someone gets upset about it because it looks like you may have talked about board business, or you can just be safe and not do that. I think a lot of attorneys would caution and say better safe than sorry. So that's also a useful example to know kind of what a chance meeting looks like. So again, picking up the phone, something that requires deliberate intent of dialing a number or selecting a contact, that would not fall under chance meeting as typically anticipated in the PMA. So what if one or more members cannot attend a meeting in person? The absent member may participate telephonically, but all votes must be roll call votes. This is so the public can know how any given board member voted. So even out in the open, even if we run a perfect meeting, everything's scheduled the way it's supposed to, everything was done out in the open, but one of you has to participate over the telephone. I guess this is important to show that we have to loop the public in so much, and it's so important that we do so, that even it comes down to, even if one person participates over the phone and everyone knows how they voted, we still have to at least show our work and say, hey, we're, public, we're an open book. Everything's out in the sunshine. Here's how everyone voted, since there may be one or more people here who you can't physically see who delivered a vote. So just another example of how far the PMA can go. So again, if one or more members cannot attend a meeting in person, if those members present in person make a quorum, then the meeting may proceed as normal, with the other members participating by phone or electronic means of communication. However, per department policy, any member attending by electronic means of communication does not count towards a quorum. We do require a physical in-person quorum. So for purposes of quorum, again, attorneys are anxious statistician people, rather be safe than sorry. Just so the public is fully aware of who is and is not participating and who's available and how those votes go. The department only counts people physically present for the meeting in regards to a quorum. So this is a Tennessee case from 1990 speaking about the Public Meetings Act, and it basically says the act is to be construed most favorably to the public and is all-encompassing and applies to every meeting of a governing body except where the statute on its face excludes its application. So if anything were to ever come up, there is case law here that's well established at this point that all ties will go to the runner of the public. All close calls will be in favor of the public. And we are going to assume that it applies to every meeting of every governing body unless it specifically says it does not apply. So just a nice reminder that the Tennessee lawmakers take the sanctity of the Public Meetings Act so seriously that any ties or any close calls, those are always going to be in favor of the public. And I'll just go through this quickly, but this is actually something I guess, as I said this morning, we've always implemented availability for public comment, and now we're making it just a little more clear in case people weren't sure. But the public has a right to attend and observe meetings. They don't necessarily have the right to participate, but the department does permit public comment so long as it's not disruptive to the flow of the board meeting. So we have to give notice about a board meeting that is happening. That's part of it being out in the open, is that if people want to be here or if they want to talk or if they want to watch online, they have to know when it's happening and where it's happening. So basically there is a legal test, a 3-pronged test of how do we know you gave good enough notice? The first one is the contents of the notice must reasonably describe the purpose of the meeting or the proposed action to be taken. So did you describe the purpose well enough? Next slide, please. Second, notice must be posted at a time sufficiently in advance of the actual meeting in order to give citizens both an opportunity to become aware of and attend it. So again, 1, did you describe what you were doing well enough? 2, did you tell people well enough ahead of time? It doesn't help that much if if we start at 10 and at 9:50 the day of, we post that we're having a meeting. And then finally, notice must be posted in a location where a member of the community could become aware of such notice. Internet, newspapers, bill postings, things of that nature. So posting a notice online to meet the adequate public notice requirements is contingent on facts and circumstances behind the posting and whether the location would be one where members of the community would become aware. So usually what we do is we publish notice of the meetings on the board's website and the department's website, and that online forum is generally sufficient for passing that prong. So a Tennessee Court of Appeals has stated whether public notice is adequate is in all the facts and circumstances analysis. No single factor is dispositive. So they're just going to look, at facts and circumstances, what we did, what we didn't do, look at those 3 prongs, not necessarily in a vacuum, and analyze them. No one prong is stronger than the other one. So what do we do whenever we messed up and we had a meeting and didn't do everything we're supposed to in the Public Meetings Act? Legal effect is nullity. So essentially, all the work you did in that meeting, think about today, everything you guys have done today, if we didn't do it right, it just gets wiped clean. Doesn't count because we did not give the public a heads up. And that's just how important it is that the public know what's going on, when it's going on, and how they can participate if they want to participate. Because if I guess we think about board meetings of, our administrators, legal, and the board members, but in actuality, it's a 4-part. It's also the public. I know we don't always have people here from the public, but even when we do not have them physically present, they're still very much necessary and probably the most important part of this overall function. So, in a nutshell, Public Meetings Act is designed to make sure all board business is conducted in a way accessible to the public, and it applies to you both as a member, individual member, and collectively as the board. So again, I think the big takeaway is the accidentally doing board business. I think it's easy to fall into. I'm sure none of you have, but it's just always a good reminder of if it's something that you think would be good to bring up at the board meeting, then the board meeting is where it should stay. So further round up the summary, all gatherings of more than one member are meetings. That's that Whole Foods run-in and are covered by the PMA, including regular, special, and emergency meetings, and including committee and subcommittee meetings. The only exception is when you have that executive session, which is your opportunity to ask your attorney questions, but you may not deliberate or decide anything. Once you start deliberating, deciding, that's board activity to a T. For every meeting, you must give adequate public notice in content, location, and time. And if you violate any of that, then all acts that you do in that meeting are void, and courts don't like it when you do that too. So if it were something big that went to litigation, they could potentially assign the cost of litigation to the board. Okay. This is a Supreme Court case, not just Tennessee Supreme Court, the Supreme Court. That the next slide, please. Basically, the short version is that a North Carolina Board of Dental Examiners issued 47 cease and desist orders to non-dentists about teeth whitening. In response, the FTC filed a complaint saying that they violated antitrust laws by unilaterally ordering non-dentists to stop providing whitening services. The board argued state action immunity, and the FTC ultimately won at the Supreme Court. So what that means basically is that they were controlling how people could and could not enter the industry. And even though they weren't applying to be licensors, they were in a unique position of being on a board to where they could tell people, no, you're not allowed to do that, and kind of leaving that for those who were licensed. So a big question raised in this decision was, what is active state supervision? Quote, the inquiry regarding active supervision is flexible and context dependent. Active supervision need not entail day-to-day involvement in an agency's operations or micromanagement of its every decision. Rather, the question is whether the state's review mechanisms provide realistic assurance that a non-sovereign actor's anti-competitive conduct promotes state policy rather than merely the party's individual interest. So, as an attempt to translate that from legalese, basically, active state supervision is limited to this dental board should have been promoting the interests of the state, of protecting consumers, of, I guess, establishing a cutoff of reliability and competency of becoming dentists. Instead, what it seems like they did in this case is that they promoted the party's own individual interests. The board had an interest to maybe keep these people to avoid licensure out, and potentially promoted that instead. So who is a supervising official? Commissioner or chief executive officer of the administrative department under which the regulatory board operates or to which the board is administratively attached, or commissioner or officer's designee. One more over. Maybe one more. There we go. Sorry, went a little too quick. So the role of a supervising official is, this is straight from the statute in 4-4125. Each supervising official shall ensure that the actions of regulatory boards that displace competition are consistent with a clearly articulated state policy. So again, in that North Carolina case where the board said, no, these non-licensed teeth whiteners cannot come into the industry. If there had been some articulated state policy of, we have a lot of concern with non-qualified teeth whiteners coming into the industry, then at that point you're advancing the state functions concerns and their policy as opposed to the individual's agenda. So other than rulemaking, the supervising official shall evaluate whether the action may constitute a potential unreasonable restraint of trade that requires further review. And there's kind of a checklist that if it is determined that an action requires further review, you have to provide notice, you have to review the full evidentiary record, conduct a review of the substance of the action de novo, and in writing, approve, remand, or veto that action. So I guess a big takeaway from that, I know that's a huge chunk of legalese, and it's as someone who read a lot of Supreme Court opinions in law school, that's not an easy one to read. But I think the takeaway is that at the end of the day, when you're up here deciding on people coming into the industry, deciding things on the legal report, making decisions as a board, if you keep it centralized to let's focus on what's in front of us, not barring entry into the industry unfairly, and let's just focus on what we have right in front of us, not larger policy of what am I interested in, how do I feel as an individual licensee about coming in versus what does the state feel, what are the state's policies and thoughts and approaches. I think so long as it's contained within what's directly in front of them, directly in front of this board, then you'll be just fine. That case is a little bit difficult to work through sometimes, but I think that's the primary takeaway. So I imagine there may be plenty of questions. If you have questions now, feel free to ask. If you think of one later on the way home, feel free to send me an email on it. Happy to answer whatever I can. Don't include each other in the email. That would be a test, and you would fail on that one. But that is the gist of it. If anyone has any questions now, I'll be happy to answer.
Any questions from the board members for Mr. Bryant? All right. If not, thank you for your presentation. We appreciate that. All right, we're going to move on with new business. I will bring forward past president luncheon. Would everyone's schedule in November be available for doing this to honor Mr. Rahm in November? Does anybody have a after our regular meeting? Yes. In our November 14th meeting, following that meeting. Everybody okay with that? All right. So we will plan to honor Mr. Rahm for his past service to this board in November. Also at this time, we started this last year. We want to open the floor to give any board member that has the intent of serving in 2024 for any position. If you'd like to express that now so we can get that out in the open before this board, we'll open the floor for that at this time.
I know this is August, and when we come back in October, we'll only have a couple of months left, and I think everybody knows we're going to lose 3 people with lots of wisdom at one time. So us rookies will try to do you good. But Ms. Pam, I know that you started late, and you've got 1 more year on the board. And if you're interested, I wish that you would speak up for the role of president. And I've got 2 more years, and if everybody has faith in that, I'd like to put my name in the hat for vice president next year. And I'll leave it at that.
I would be honored to serve in that capacity. That's a January 1 till December calendar year. But I appreciate your confidence. Thank you. Thanks.
All right. Anyone else before the board on this? All right. If not, we will move to public comment. We'll open at this time, could be in person or anyone online. We will open the floor for public comment at this time. Do you have anybody, Ms. Bohannon?
There's nobody online for public comments and nobody indicated on the sign-in sheet for public comments.
Okay. Mr. Gerber?
Harris, before you adjourn, I would ask you to recess again for just a few minutes. I need to speak to legal counsel, and if the board would recess for just a few minutes.
Okay.
We'll step out.
So for just a moment, we'll recess for Mr. Gribble and legal to speak, and then we will reconvene before we adjourn.
I realize time is of the essence.
Resume our meeting, and we'll hear from Mr. Gribble and legal.
Okay, so after a discussion with administration and
He
legal,
is now joining.
we would like to ask that the board at least entertain a motion to reconsider the earlier application in reference to, I want to get their name correct, 1 second.
Before we go back into that, do we need to recuse those that were recused or not?
Yes, that was going to be my next, that if we go into that, unfortunately, Mr. Berry, I'm sorry. Yes, yep.
Is now exiting.
Just going to leave us. I'll see.
Tell Kelly we said
And just to get their name on the record. That would be in regards to Circle of Life Cremation LLC. So I guess the first thing I want to emphasize is that board is more than within their purview to ask questions, ask for additional documentation or photographs or anything like that. That's more than fine. Though I guess where the caution and the concern comes from that at the end of the day, kind of our tools and our tool belts are statutes and our rules. And if something doesn't necessarily run afoul of those or is a violation or anything like that, then I think the board's purview and I guess it gets to be a more narrow decision, so to speak. So again, I do want to make very clear that, asking for additional documentation or things like that, totally okay. But at the end of the day, if that it triggers a denial, which I know the board did not deny the application earlier today, or tabling something, at the end of the day, its backbone needs to be on a concern about a potential violation with a rule or a statute. So all of that to say, long-winded, that we would ask that the board entertain a motion to reconsider. And if the board does do so, of the 4 who voted no, the one who brings the motion and the one who seconds it should be from that group of 4 board members who voted no on the earlier.
Okay, we've heard from legal, bringing the applicant back before us that we left the application open, but asked for more information in the next meeting, if that's fair to say. We'll leave it open at that if anybody wants to make a new motion, and we'll go from there.
So is the recommendation to approve it?
Well, that's a board decision. But again, I would say that at the end of the day, if a denial or a tabling or a request for further information, it needs to be linked to a specific enumerated statute or rule. If there's a concern about, I recall there was a request for further information on an application a few months ago in regards to a fixed place of business. That's an articulable, the board has this concern about this rule that is on the books. That's perfectly fine. So again, long-winded way to answer your question, Ms. Stevens, but what the board ultimately decides to do is the board's decision. But I would just, again, caution strongly that if the board decides to table it and ask for more information, or decides to deny the application, that there is a statute or a rule concern that can be specifically pointed to. And again, first, I guess, before we even get to what the board may decide, the board needs to do a motion first to reconsider.
Which, before we do that, am I correct in saying we did not deny?
That is my understanding. The application was not denied.
Correct. Okay. Other questions or anybody that wants to make a new motion other than what we made earlier?
I'll make the motion. I'd like to make a motion that we restate our previous, you're going to have to help me with this motion, our previous information regarding Circle of Life cremation, and that we accept the application with the understanding that within 30 days, information that we requested on a place she can use for viewing of loved
Okay, so I think first, that was an excellent.
Oh, it wasn't.
So I think first, before we get there, we have to kind of two hoops to jump through. The first one is a motion to reconsider. So I think you can just leave it at that. Like open motion to reconsider, or I move to reconsider the former decision in regards of Circle of Life LLC.
That's my motion.
Okay.
All right, so we have a motion by Ms. Stevens to reopen the Circle of Life cremation for reconsideration. Do we have a second to that motion?
It does, yes.
All right, with no second, that means it ceases from your advice?
Yeah, without a second motion, the reconsideration does not open. So,
okay. So one last time, we do have a motion on the table to reconsider. Again, any second to come forward. All right. No second. That will stand as our decision on Circle of Life cremation.
yes. The record should show that you opened the motion, did not receive a second, so the motion did not pass.
Okay. All right. Any other new business to come before this body?
Mr. Harris, I'd like to make a motion that we adjourn.
All right. We have a motion by Mrs. Stevens to adjourn. I have a second by multiple, Mr. Porch, Ms. Haynes. So officially at 1:52, without any objection, all in favor say aye.
Aye.
Aye. Thank you.